I'm going to turn it over to our gracious host, Estefanita Rawlings.
Okay, good morning, and welcome to New Mexico Small Business Development Center, called the Technology Commercialization Accelerator's 6th Annual World IP Celebration. Online, we have representatives from the USPTO office, from the US Copyright Office, and from New Mexico Small Business Assistance Program. I'm going to do a little introduction, and then I will bring our guest speakers and introduce them as they come on. Over the next couple of hours, we'll be talking about what intellectual property is and the different ways it can be protected. Each year, on or around April 26th, people around the world come together to celebrate intellectual property and the role it plays in innovation and creativity. Because every country has its own system for protecting intellectual property, the World Intellectual Property Organization, WIPO, WIPO, was established to create a more creative, cooperative framework. WIPO administers international agreements like the Patent Cooperation Treaty and the Madrid System, which make it easier to seek protection across multiple countries. For there is no single global intellectual property right, these systems help streamline the process. To recognize the importance of intellectual property worldwide, WIPO established World IP Day, celebrated annually on April 26th with a different theme each year. My name is Estefanita, or Steffi Rawlings, and I am the Center Director of the New Mexico Small Business Development Center, called Technology Commercialization Accelerator, here at New Mexico Tech in Socorro, New Mexico. It is my pleasure to welcome you and our panelists to our 6th Annual World Intellectual Property Celebration. This year's theme is IP, intellectual property, and sports. Ready, set, innovate. Intellectual property plays a major role in the sports industry. We see patents protecting new equipment and performance technologies, trademarks for team names, logos, and merchandise, and trademarks for team names, logos, and merchandise, and copyrights in broadcasting, podcasts, and marketing materials. And of course, there are trade secrets behind training methods, analytics, and business strategies. For example, think about a company like Nike. Their shoe designs can be patented, their logo is trademarked, and their marketing campaigns are protected by copyright. IP is truly everywhere, even in something as familiar as sports.
How are you?
Hey, good.
Good.
All right.
Yeah, I seen you.
Good to see you.
Okay. IP truly is everywhere, even in something as familiar as sports. And whether you're here with a business, an idea, or just curiosity, intellectual property touches all of us in some way. Let me take a few minutes to tell you about our center and the broader network we are part of. New Mexico Small Business Development Center Technology Commercialization Accelerator operates as part of the statewide New Mexico Small Business Development Center network. We are guided under the leadership of our Executive Director, Russell Wyrick, whose vision continues to strengthen and grow our programs across the state. He has been instrumental in ensuring that we, as advisors, continue to develop professionally so we can serve our clients. This includes ongoing training in business education, artificial intelligence, and cybersecurity, so we can bring relevant and practical knowledge back to the entrepreneurs we support. The New Mexico SBDC ecosystem includes 19 centers across the state, all working together to support businesses at every stage of their journey. whether someone is just starting with an idea, currently running a business, or planning an exit. The SBDC provides guidance along the way. We work one-on-one with clients to help them understand the process of starting a business, growing a business, and transitioning out of a business. Everything from business planning and for financial projections to compliance and access to capital. A big part of our mission is education. We don't just tell clients what to do. We help them understand the process so they can make informed decisions and build sustainable businesses. At the end of the day, our goal is to develop skilled entrepreneurs and strengthen businesses across New Mexico. Now, within that network, my program, the Technology Commercialization Accelerator, focuses specifically on intellectual property and cybersecurity. This program started 6 years ago with very simple resources, a web page, a cell phone, and a vision. Within the first year of using tools like Zoom, I organized TCA's first World IP Day event. And now here we are, our 6th annual celebration. So thank you for attending. Our focus to help New Mexico residents understand the options available to protect their innovations. We guide clients through questions like, what type of IP protection fits their idea? How does the patent process work? How do you conduct a prior art search? We also connect clients to resources across the state for testing and commercialization. We make sure they're not navigating this process alone. Another key part of our work is cybersecurity. Protecting a business today goes beyond just protecting an idea. It also means protecting your data, your systems, and operations. During October, Cybersecurity Awareness Month, we host weekly presentations with experts from Apex Accelerator regarding CMMC guidance and CISA for cyber basics for small businesses. We also work with New Mexico Tech Cybersecurity of Excellence program, and they have been a partner in our effort. We do this because strong businesses must also be resilient businesses. Now let's talk about why intellectual property matters. IP drives innovation, it creates new industries, new businesses, and new jobs. It attracts investment, supports global trade, and contributes to economic growth. When people know their ideas can be protected, they are more willing to invest time and money into research and development. They're more willing to take risks. And that is where innovation happens. This leads to new progress and sometimes entirely new industries. IP-intensive industries like technology, entertainment, biotech, and manufacturing employ millions and create high-paying jobs. Strong IP systems also support startups and help businesses grow and scale. From an investment perspective, IP is critical. Investors look for protected ideas because it reduces risks, creates a competitive advantage, and signals long-term value. So when we talk about intellectual property, we're not just talking about legal protections. We're talking about economic development. We have our speakers from the USPTO and copyright, all intellectual property. We will also have a brief presentation from the New Mexico Small Business Assistance Program called the NMSBA. This program connects small businesses with scientists and engineers from Sandia National Labs, Los Alamos National Laboratory, and our state's major universities, UNM, New Mexico Tech, and New Mexico State. Through this program, businesses can solve technical challenges and move their innovations forward. With that in mind, it's important to hear directly from the experts. Today, we are joined by speakers from the United States Patent and Trademark Office, the U.S. Copyright Office, and our partners, NMSBA. They will share insights and resources to support you and your businesses. With that, I want to introduce our speaker lineup and some ground rules. We will have a presentation on trademarks presented by Reynaldo Vasquez from the Southwest Outreach Regional Office out of Dallas. A presentation on copyrights presented by George Tironi from the U.S. Copyright Office and a patent presentation by Hope Shimabuku from the Southwest Regional Outreach USPTO Office. And finally, Judy Hendricks from the New Mexico SBA program. Most of our presenters will talk for approximately 30 minutes with a 15-minute Q&A session. Please put your questions in the Q&A tab and they will be answered during the Q&A session. Also, I want to congratulate our Southwest Regional Outreach USPTO Office on their 10th year celebration that they will be celebrating next month. And also, I want to remind attendees that we will be posting the recorded presentation on our YouTube channel called New Mexico NMSBGC, and the slides will be distributed. In return for this no-cost webinar, we request that you complete the survey that will be presented prior to closing. We conduct surveys to collect feedback and provide meaningful insights to our stakeholders. And with that, I would like to introduce our first speaker, Reynaldo Vasquez.
Thank you very much, Steffi, and thank you for the shout out for our 10 year. Coming up next month here in the Dallas area, so in case anybody wants to come on by. It's going to be strictly in person, trying to have more in-person engagements. But glad to be here with you today. Every community that we work with has a catalyst like Steffi here. So that's catalyst really helps us connect with the local community. And we've been working with Steffi here for a good while. Honestly, I would say at least 5 years since I've been here, Steffi. So I'm glad that we have your partnership and your collaboration. With that being said, I'm going to talk about trademarks today. So I am with the U.S. Patent and Trademark Office. I've been here for about 5 years. I came from the SBA world, so the Small Business Administration. I used to do economic development there, a little bit of international trade, veteran business development, research and development funds. And then I transferred over to the USPTO, a lot of IP economic development here. It's more concentrated niche, I always say. And it's important for entrepreneurs to really understand IP. In particular, I'll be talking about trademarks. Trademarks, I always find them to be a little bit more of the fun conversation. It's something that we interact with as consumers every day. At the end of the day, they're consumer protection laws. So you want to consider trademarks as being consumer protection laws. But they also help businesses really brand their products and services. So you'll see these trademarks every day, but a lot of times you don't really understand how they work, and that's what we're trying to help you understand a little bit better. Can everybody see my screen now?
Yes.
Okay, thank you, Chris.
Yes.
So interesting fact, the USPTO actually has their federal trademark, their federal logo trademarked. So it's a registered trademark, as you can see the registered R here in the bottom. And pretty much what that means is that, the logo within the USPTO has been reviewed by our office to be a registered trademark within the US. Federal agencies don't have to do this, they're protected under federal law. But we decided to do this a couple of years ago just to show precedent and help us combat fraud as well. Government agencies also do get targeted for fraud, so it's one of the things that we were able to do. So today we'll talk about trademark basics. This is my information. You guys can call me Ray for short. I'll give a quick overview of what the office is and what we do. So the USPTO, we are under the Department of Commerce. We're a fee-based agency, so we don't receive taxpayer funding. We pretty much operate based off fees that we collect on patents and trademarks. In here, you'll see our employee count. This is by the end of fiscal year 2025, so it's changed a little bit. But we have about 14,000 employees. Most of them will be patent examiners. It does take a lot more individuals to examine technology and new applications that come into the office than like trademarks would do, just because the business, the nature of the business itself. We have about 800 trademark examining attorneys, and then in here you'll see the volume that we receive. This is what helps us regenerate revenue at the end of the day. So we have these patent filings that come in every fiscal year, and trademarks is always higher just because it's more friendlier or more applicable to businesses. And we'll talk about, common law and registered trademarks right now. Down here in the bottom, you'll see the USPTO headquarters is in Alexandria, Virginia. So if you're ever in the area, definitely recommend you to visit. It's a beautiful campus. Thanks to the Americans Invents Act that was passed in 2011, we were able to expand. So now we have offices all over the U.S. Our office is in Southwest Regional Outreach Office in Dallas, Texas. And we do cover the state of Texas, Oklahoma, New Mexico, Kansas, and Missouri. The other offices around the nation will cover a respective territory within the office. And basically what we do, we help educate the public on intellectual property. We do stakeholder engagements, help them gather feedback for the office, and also help with recruitment efforts. And we also push, agency initiatives that we have throughout the year. Like Steffi mentioned, we have WIPO, IP Day, with IP and sports. And we've been pretty busy with that. We were actually at the NFL draft this year too, promoting not only trademarks, but the difference between trademarks and NIL, name, image, and likeness, which I'll touch on shortly. So this is our office in downtown Dallas. So in case you're ever in town, feel free to visit us. Send us an email just to make sure we're in the area. Hope and I do stay pretty busy. But for the most part, we have patent examiners that come in that want to have an office in a location. They do have the ability to work from home, so a lot of them will take that. But there's a handful of them that actually do want to have an office, and that's why they'll come into our building here. We have our PTAB judges, not only them doing hearings that they have every week, but they also have management duties, such as myself and Hope. Hope will be doing the patent presentation a little bit later. And then we have some of the trademark personnel as well in here. But just so you know, if you put in an application for the USPTO for a patent or trademark, that can go anywhere in the US. So our examiners have the ability to be working from home. So somebody in Washington State or New York can be examining your application. It doesn't necessarily come into our region. So that's our hours of operation. So let's talk about trademarks that we're here for. So what is a trademark? A trademark is a word, phrase, symbol, or design, or a combination of words, phrases, symbols, or designs that identifies and distinguishes the source of goods of one party from those of others. In short, it's a source identifier. It helps you identify a product or service from those of others. It does distinguish that. Everybody here, I'm sure, has their favorite trademarks and brands that they follow. A service mark, a lot of times, it's used interchangeably as a trademark. A lot of times people don't say I have a service mark for my engineering business or construction business, and they just say I have a trademark. But it's pretty much a service that identifies, those sources of goods, in particular services. So one of the things I wanted to point out here is that the 15 USC code, section 1127, will tell you more in depth what trademarks are. It follows the Lanham Act, and the Lanham Act is the Trademark Act that governs the trademarks, so the first one. And that's what really patents and copyrights were actually in the US Constitution, but trademarks are actually had to be established beforehand. So these symbols you can use when you have trademarks. You have a TM for a trademark, SM for service mark, but you could only use a registered R once you have it registered with a governing function. In the US and its territories, it would be the USPTO, so it would have to be registered with us. And so you have to understand what trademarks can be used as long as they're in commerce. So that falls under what we call common law trademark. So a lot of that falls under state rights. So a trademark can be used in commerce in connection with any specific good and service, but it's not registered. So if you have a business and you're operating in New Mexico, you can use the TM. That's your notice to the public saying that you're operating under this trademark, and you can use the TM or the SM if it's applicable. one of the things for common law trademarks, it's like I mentioned, it's more states' rights, so it's gonna your geographical area is gonna be limited. One of the pros of having a registered trademark, and I'll touch a little bit more on it right now, would be that the USPTO would give you a jurisdiction of the United States. So you would have that registered trademark in the US and its territories. An important thing to understand for trademarks as well is that the US is a first to use country. So once you start using them in commerce, you can obtain common law trademarks, and then once you register them, you can obtain the trademarks in the US itself. There are some stories, in commerce that businesses like one that I kind of like is the Burger King one. I think it's in the state of Michigan. They're able to operate. Burger King is able to operate under the name Burger King because they were in use in commerce before the franchise Burger King was established and registered in the United States. So that allows them to be grandfathered in within that specific territory. But since they didn't have a registered trademark, they couldn't expand to the United States and have that protection. So first to use is very important to understand it in trademarks. And we'll talk about copyrights and patents and trade and other forms of IP. Just so you understand it, these are all forms of intellectual property, and they do have their own subject matter expertise and their own laws. Some do overlap, but some of them do differ. And you'll see a lot of overlap with copyrights and trademarks. So registered trademarks has a lot of benefits. So you can register it with the USPTO. It gives you the territory, the US and its territories, so that's a big plus. You can use federal district courts for your enforcement. So enforcement is always on behalf of the IP holder. So that is something that you're responsible for, not something that the USPTO would really get into, or commercialization. We're mainly in charge of the granting of trademarks and patents and the registration of trademarks. But you really want to be aware of this because the federal district courts can give you a lot more leverage as well. And then once you have the registered trademark, you can use a registered R symbol to indicate to the public and put a notice that this trademark is registered. Another thing that you want to take into consideration for trademarks is that there's different international classes. So these classes will distinguish your trademark within the goods and services that you operate in. So if you're selling, let's say food, for example, you would get that trademark under the food classification. But if you're also doing apparel, that's another trademark in a different classification. But you have to be using it in commerce in order for you to qualify for a registered trademark. It's one of those things that I can't just sit here and think of names and just start trademarking them. It has to be used in commerce. And same thing with common law. It has to be used in commerce for it to be applied to a trademark. One thing that you want to do is do your search on the trademark search system. So at the USPTO, we have a database of trademarks that are registered. In there, they'll tell you if they're alive or dead. Live, it means that they're still active. Dead, it means that they're abandoned. But one of the things that you can help you do to save yourself some time and service, and it's really your due diligence as a small business and entrepreneur, is that you want to make sure that your trademark is not infringing upon somebody else's. So the name being one for one, that's a big, infringement. That name's already taken. It's very similar. The other side is likelihood of confusion, which is a big component to the trademark infringement. You can't also be very similar to another brand, especially if it's in the same category. That gives you a lot of issues. So I always tell people, make sure you're doing your due diligence and make sure, similar to doing a business plan and doing your homework, you just want to make sure you're doing a quick search on the trademark database system that we have that gives you all the registered trademarks. You can go more in depth in the trademarks, especially in the likelihood of confusion, because that can become a little bit complex in searching. It's not just like a simple text word search. You have to go a little bit with more code, special coding to be able to find it. But we do provide trainings online, and those are actually very popular trainings that we do throughout the year. it talks about not only searching, but like we talk about likelihood of confusion more in depth, talking about the different classes or classifications. I talk about the clearance of searching. These tags help you understand what's out there and helps you really save time and money. Because what we see a lot is small businesses come to us once it's already too late. They haven't really done a thorough search on their trademarks, and they start using a trademark in commerce that's already taken, or they get a cease and desist letter from an individual that is claiming to have likelihood of confusion. So these issues can be costly, especially in litigation. So it's one of the things that you want to set yourself up to have a strong trademark, but also something that's not already infringing upon somebody else's. I always tell people it's a double-edged sword. You want to protect your IP, in this case, the trademark, but you also want to make sure you're not infringing upon somebody else's. So in here in the trademark search database and link, you can find the trademark database that we have and useful references and resources. Trademarks are actually simple but powerful. Trademarks can be words and designs. For example, you have these words that are famously known, like a Starbucks, Nike, Target, but you also have the design that's trademarked. So these are two different trademarks that are protected. The word itself and then the design is also protected. And once you see them, and once you hear the word, you automatically know what the product and services are and the origin of them. But trademarks can actually also be very powerful, and they can also be colors. This Tiffany and Company blue or turquoise or blue that they have, it's a specific color that they wouldn't been able to trademark in the jewelry industry. So that's the specific color that they have trademarked and protected. UPS with the delivery trucks being brown and yellow or brown and gold is protected. So it has that protection of a trademark. Once you see these specific transportation vehicles, it's UPS. And John Deere, the green and yellow, pretty distinguishing trademark for tractors. You can't have other green and yellow tractors and not get some issues with John Deere, specifically on their trademark infringement. You could see other colors, and now you're starting to see other colors in trademark in tractors for like a black and red, and I've seen blue and black as well. So there's different colors, but they don't replicate the trademark that John Deere has established. Scents can also be trademarks. So Crayola, the specific scent the crayons have, it's a trademark that's protected. And then Play-Doh is the famous one. Everybody remembers Play-Doh and the way it smells. As soon as I say the word Play-Doh and scent, you automatically come into mind like, oh, that's a very distinguishing particular scent that's protected under Play-Doh. Sounds can actually also be trademarks, and they're used a lot in the industry, in the movie industry or entertainment industry. The Star Wars, the Darth Vader, the breathing specifically is very distinguishing, and that's something that's protected. And then even the lightsaber, once you hear the lightsaber sound, it already comes to mind. You already automatically are having your mind have that origin of good and services. And then you have the NBC Shine. When it comes out, it gives you a particular sound. A lot of companies do this with their products and their branding is protected. And then even Buc-ee's has become very popular here. They love their trademarks. The name's trademark, the logo's trademark, and they even have a sound trademark. So if you ever walk into a Buc-ee's and they take out a brisket, they're supposed to start singing "All Brisket on Board," and it's supposed to be like a locomotive tune. And that sound is trademarked by Buc-ee's as well. So there's a trade dress trademark to specifically have products that are protected in the way they look. And the example of Apple is the way it's configured. So you see the Hershey's Kisses, the specific way that they sell chocolates, and the chocolate dropping is protected. The Doc Martens, the soles themselves are very particular, and that's a trademark that's protected. The Coca-Cola bottle itself is a trade dress that's protected as well. So other things that are related concepts but are not trademarks. So domain name registration, and we get this one a lot because once people register with the state, they think they have a trademark. This does not create a trademark registration. So you remember when I mentioned common law trademarks, you have to be using it in commerce, first of all, to operate as a common law. And then in order for you to register it, it has to be registered to a government function such as the USPTO for its territory. The domain name registration with the state or the county as well, that's only going to give you the domain name, the business name for that county or state. So that doesn't necessarily mean a trademark itself. So just so you know that that will limit your business in jurisdiction. So if you don't have it, it allows you to use it in that state for business, but it doesn't create the trademark. So it's being territorial, it's being strategic at the end of the day. Just because the state have it, like in New Mexico, it doesn't mean that somebody in New York doesn't already have a registered trademark in the United States. And that would be a trademark infringement. So you're trying to avoid these issues at the end of the day, and you're doing your due diligence and you're doing your research. The other concept that comes into trademarks is NIL. So name, image, and likeness. These really fall under individual rights, at least they're known as publicity rights as well. But trademark protects the components of your brand, things that you use in commerce at the end of the day for your goods and services. Name, image, and likeness protects the right of publicity, so individual rights. So again, this example gives you the Jordan logo. Different between that's registered under Jordan or Nike, and your name, image, and likeness is different. That's individual rights and an individual has. And this actually became popular with the NCAA case ruling that happened a couple years ago and allowed individuals to take name, image, and likeness for college athletes. So I'll talk about USPTO resources specifically relating to trademarks, and then we can kind of go on to questions that you may have. So number one resource I would say is that we have our website, uspto.gov. We have a lot of trainings going on throughout the year and a lot of updates on IP. So if you want to stay more informed with intellectual property updates and specifically trademarks and patents, feel free to register with us. The number one training that we have for trainings is called the Trademarks Basic Bootcamp. It's actually the most popular training that we have because, like I mentioned, every business that's doing commerce in the United States has either common law and trademarks, and they can pursue the federal trademark registration. And in these, we go more in depth of what trademarks are and how to register them, how to do trademark searching, for example, and some best practices as well. We do have a 1-800 hotline. They can't give you any legal advice, but they can help you. It says first-time filers, they get assistance, but even the legal community also gets a lot of assistance as well. So this is individuals, paralegals, and attorneys. We just can't give any legal advice. We definitely help them through the trademark application process in case one decides to do on their own. For pro bono, we do have law school clinics. So this is where second and third year law school students under a clinic supervisor can provide pro bono assistance to small businesses and entrepreneurs. And they help them through while they're learning. So law school students, while they're learning to do trademark applications in this case, can help you as well through that pro bono exchange. And then the last resource that we have is the PTRCs, Patent and Trademark Resource Centers. This is where we train community librarians to help you do patent and trademark research. You can learn it on your own. We have YouTube channels, we have trainings online that are dedicated for searching, but it also helps having that expertise locally. So these community librarians in your area can help you navigate through the trademark and patent searching. And then follow us on social media. We stay active, trying to educate people on IP, try to be relevant on IPs and inventions going on. Like we're just mentioning patents and trademarks right now with the NFL because the draft just happened last week. But we try to make it interesting, not only with World IP Day, but just different things that are going on throughout the year. And that's our information, Southwest at uspto.gov. Feel free to send us an email. We do cover the whole state of New Mexico. So any way we can help you in your business ventures, feel free to reach out, especially if you want to have a one-on-one, just talk about your case a little bit more, your situation a little bit more. Just remember, we can't give legal advice, but we can definitely help you through guidance and education. And that's it. Let's see what questions do we have.
Okay, we have one that says from Adriana. So I have LLC, can I add TM to my business name?
So once you have a business name in commerce, you can add the TM for it under common law trademarks. The only thing is, Adriana, you want to make sure that you're not infringing upon somebody else's trademark, and that could be the one-for-one name that I mentioned. So if there's a specific name with the same business name somewhere else, that can cause trademark infringement, or even something that's very similar to that trademark can also cause likelihood of confusion, which is a trademark infringement. It depends on the business. If SM would be for services. So you can use TM or SM. It's used interchangeably at the end of the day. If you want it to be more specific for services, like a plumbing service or construction services, engineering services, consulting services, that all can use SM because they're services at the end of the day, but you can also use TM because it's used interchangeably.
Ray, I have a question. You
Yeah.
mentioned your class, the trademark.
The classes,
Yes.
international
Do you know?
class.
Yes. Do you know when you'll be offering them again? I used to see them like all the time, and they haven't been
You're talking about the
advertised.
the trainings themselves. I do know trademarks. We actually hired the manager there, Jason Lott. I'm sure you know Steffi. He's with us covering the San Jose and the Western office. But I do know they're supposed to continue to do the trademark basic boot camp. I just don't know when they're going to be rolling them out again. But they should be continuing those trademark basic boot camps. You can always reference the YouTube channel just to get the recordings out of it. But yeah, it's always we always definitely recommend to do the live one just because it's more up to date, and you can ask live questions to the speaker. But feel free to reach out to us as well, like in case you have any questions on trademarks and trademark registration process.
Okay, we're getting some questions. This is good. Jacqueline asked, when is the summit event?
Our 10-year program, it's on May 11th, Monday, May 11th, in the Dallas area, here in the Dallas Arts District Mansion. I can put the link in the chat if you guys like right now.
Okay, so then we have another question. How could I categorize a home service that deals with health, hospital, and hospitality and personal assistance? And what do you mean by in commerce?
So when you categorize, your trademark, you put in a description of what you're doing, and the trademark examining attorney will only be able to give you a trademark classification based on what you're doing in commerce. They have to actually they have to vet that you're actually using it in commerce. In business, in other words, I know you mentioned what do you mean in commerce? When you're using it in commerce, I mean you're using it in business. At the end of the day, you're selling it, online. You're selling it in a flea market. These are specimens that an individual would pretty much send in to the office so they can verify it.
Okay.
Mm-hmm.
And on that, if somebody closes their business and they have an active trademark, they're no longer in commerce, they can't own it anymore. What happens?
They're supposed to do a form to report it to the office so they can put it abandoned, the technical term. Another individual can actually also notify USPTO. I got dogs barking here.
Oh, you were cutting out a bit.
Yeah, no worries. It's just you have to notify the USPTO themselves.
Okay. 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 And then they said, okay. So then Carl has a question. Can you trademark a product and now?
You trademark product.
Can you trademark a product and can you do it now?
I'm trying to get the question. Like once you start using that trademark in commerce, you have common law, right? Trademark. But the registration, the federal registration, you still have to put in that application into the USPTO.
Mhm.
Give me a second, Steffi. All right.
Okay.
Got a 18.
Okay. Okay. So yeah, Carl said, yeah, can you trademark the product now? A product, which is the product, and now? And the answer is yes. If your product is that name is unique and you're not infringing on anybody else's product name, correct?
Yeah, just remember it's fall under common law. Once you start using it in commerce, you have common law rights under that trademark. Like the registration is different. You have to put in an application for it with the USPTO for it, or federal registered trademark. You can also, some states also have state trademarks. I know the state of Texas has it. I would have to check on New Mexico. Maybe hope.
We have a trademark with the Secretary of State, a trademark office, so we can register trademarks in New Mexico.
There you go.
So
But remember, that would only just give you jurisdiction of the state of Mexico.
now, what if somebody else wanted to use that in another state and we only have it as a New Mexico trademark?
Remember, that falls into the first to use. So you could get grandfathered in to just your jurisdiction itself.
Just to the jurisdiction.
Mhm.
Okay. Okay. And then can you recommend a YouTube channel to subscribe to regarding the trademark?
It's the USPTO YouTube channel. That's the one I would recommend. I know there's a lot of content out there on individuals talking about IP, so we don't recommend other individuals, but just the USPTO channel itself.
Okay. And I have a long one here. Okay, so that's done. Okay, this is for the Navajo Nation. We are receiving payments for trademark fee. We are having issues with where the payments will be locked into. New Mexico has tribal members and want to know who would be a great resource for training for my staff. No one knows about this new venture with Navajo.
That's a great question, Loretta. I would definitely want to follow up more in an email on that. I just say we can't recommend attorneys, like we don't do the commercialization enforcement side of it. When you have a trademark register, you have assets for it, right? And you can use it to license your trademark in this example. But we don't get into the commercialization side of it. We one of the things that we can recommend is to consult with your state bar. If New Mexico had the state bar, as a matter of fact, Cope is there in New Mexico this week, meeting with the state bar. But we can't recommend like an individual to go with. And I hope you want to talk a little bit on that.
Your volume's muted. Okay.
You're not on mute, Hope, but we just can't hear you though. No, we still can't hear you.
Let me see.
But yeah, send us an email, definitely, Loretta, and see what, like I said, we can't recommend an attorney per se, but and I know that it also does overlap a lot with copyrights, especially the tribal area side of it. So I don't know if George may have any more input on that as well. But if you're saying they're trade, oh, there you go.
Go ahead.
Oh, no, never mind, Hope. We lost you again. Could be probably something's wrong with your mic. But yeah, definitely email us, Loretta. Definitely love to talk more about that and see how we can help you further.
And one year we did have some people down from Trademark, and they did talk about the Native American intellectual property too. So, okay, I put Loretta. John, we will be in contact with you too. Okay.
Thank you.
Okay. Okay. So Carl Perkins wanted to know how. Let's see. What was his question? Oh, can you can you trademark a product and how? That's his question.
So it's the source identification at the end of the day, Carl. So if you have a product, let's just say a toy, you're selling it online and you have a name for it, that you're using that trademark, that name itself in commerce, and that has common law. If you were to apply that same toy to the USPTO, your specimen is that toy and the name that you're using, for example. And that's basically, you would have to distinguish what you want to trademark, the word, the design. So you have to have a distinguishing factor at the end of the day to be able to register it. So that's where the legal terms kind of come in. And we always do recommend to consult with trademark attorneys. The consultations a lot of times are free or low cost, and they give you a lot of information to help you in your ventures. And then you can decide if you want to continue their services and pay for counsel, or you just want to pursue it on your own.
And okay, and Carl, you say where in New Mexico can I get help with my trademark? You call me and we'll talk trademarks. We'll set up a meeting with me, Carl. You have my information as you got the flyer for this class, and then we can talk trademarks and we can get you some help.
Yeah, the New Mexico State Bar is always a good source that we recommend to every state individual. We work a lot here with the State Bar of Texas as well. Like I said, we're working right now with the New Mexico State Bar as well. And they have an IP section in particular, and that's the one you want to contact for IP matters.
Oh, and you also mentioned, Ray, you mentioned pro bono. They do pro bono for trademarks also?
Correct. So the law schools, they can help you with the pro bono programs that they have. Those law schools are certified through the USPTO. So we audit them and we certify that they're legit pro bono programs. And a clinic supervisor will supervise the law school students, and second and third year law school students, as they're learning, they'll be able to help you and take in applications. Of course, they're pro bono, so they are limited to bandwidth and how much they can take per semester, but it's just a tremendous help that they have. And we did share the slides with Steffi. You can find them online at uspto.gov under the law school clinics, and Steffi can definitely share the slides with you guys, and you can find them through.
Yes, and also work with me, and we've had people go through the pro bono program for patents, but I didn't know for trademarks, so that's so good.
Yeah, well, there's a patent pro bono program, and I hope we'll talk about more of that in depth. But the law schools, they can do trademarks registrations and they can do patent registrations as well. And some law schools also do copyright registrations, but we only certify them for trademark and patent registrations.
Okay. So the USPTO registered trademarks within state jurisdiction and the U.S. state federal jurisdiction. What about international?
So if you want to do international registrations, one thing you have to understand is that intellectual property is territorial. So if you wanted to do an international registration, you would have to pick a specific area that you want to register it and go through that specific IP office. We may have a treaty, like Steffi mentioned, with WIPO that can help you expedite your trademark or your IP to that country, but we may not. So it's one of those things that you would just kind of have to understand what market you want to go into and understand what is the governing IP office for that country. And we do have some resources online, and we have IP attachés in particular that can help you navigate through customs and laws internationally. They're at U.S. embassies around the world. So like we have one in Mexico that covers New Mexico and Central America. We have one in Europe. We have 3 in China. And these IP attachés, they can help you navigate customs and laws within IP.
Okay, and then Loretta, thank you for your email. We will we'll get in contact with you. And then okay. Yes, Carl, I'll send you an email. And you're gonna get after this, you're gonna get an email from me. You're going to get the link to the stored webinar on USPTO, and then you're going to get a copy of a PDF of the slides that our presenters provided. So you'll get that. So,
And I
and
put
then,
my guys as well.
yes, and Reynaldo put his contact information in the chat. And then Stephanie has a question. So if I only do business within New Mexico, am I ineligible to apply for a registered trademark with the USPTO?
So you do have to show that you're selling your product in other interstate commerce, so outside the USPTO, outside New Mexico. A lot of times if it's online, you're selling and there's no specific, jurisdiction limiting you to New Mexico, you're selling, nationwide.
Does tourism count as having interstate commerce?
Tourism, I mean, if you're promoting it outside the New Mexico area, and you can show like a website, like I said, social media. If you're showing that you're doing it outside just New Mexico, you can. Jurisdiction is always hard to establish, especially under common law. But if you're registering it with the USPTO and you're showing that your intent is to do it nationwide, then you would get the USPTO nationwide protection.
Okay, and then I have a question from Adriana, and she says, does that mean I just gave up my rights or SM to it? And I think I'm going to allow her to talk, or do you understand the question?
Yeah, you can let her talk. Just to
Okay.
get more on it.
Okay, just a minute.
Mm.
Oh, wait, sorry. I'm a rookie here.
Who are you trying to unmute, Steffi?
Adriana Cordova. Allowed to talk. Okay. I think we did that.
Okay, cool. I unmuted it. Can you hear me?
Yes, go ahead and ask your question.
Okay. So my question actually was that I ended up just recently because I hadn't been marketing and like promoting my business that much, so I didn't have that many hours. So it was kind of under the par of the state New Mexico tax, you know what I mean? So I decided to close, which was probably a dumb idea, my New Mexico tax TAP account. So does that mean I just kind of forfeited my rights to my name and my logo and stuff? And how can I reopen it if I did?
I mean, the domain will be different. Rihanna, I remember that just establishes the name in New Mexico. Your name, your trademark under common law is once you start using it in commerce, you have common law rights. They just fall under state rights. If you use that name in commerce interstate, then you can also apply it through USPTO to get the federal trademark registration and have rights in all the United States. But remember, the trademarks can be very basic and simple. You start using it in business, selling the flea market or just doing neighbor. You have common law trademarks. They're just that simple. But the big minus on that is just your jurisdiction is very limited because you can't show that you're using it all over the state or all over the United States.
Okay, so then you're saying I can still use the SM though for my LLC because it's registered and everything here in New Mexico, but I only go to the USPTO when I'm gonna do it nationally.
Correct. If you want to get the national trademark registered, like in the United States, a lot of times, small businesses, we have to be strategic, right? So you don't need to register it with the USPTO. There's a lot of benefits to it because if somebody else was to register that name or a very similar name to it, they would limit you just to your territory and they would have coverage in the whole United States.
Okay, and then the search that they told me that you could do on the trademarks, it'll tell you the name and also the logos that are represented with that, because I'm still trying to create a logo for my company. I just don't want to like infringe on, like, say I use a house or something. I don't want to use it and somebody else has a house and a light bulb, or you know what I mean?
Mm-hmm. So we do have a new AI tool on searching that you want to use and that can help you do your search. At the end of the day, we do recommend you either take our trainings to learn more about how to do the search in depth or consult with a trademark attorney because what you want to really understand is the risk of your trademarks to somebody else's. So, a trademark professional can give you professional advice and telling you this is a high risk because it's very similar to it elsewhere registered or very low risk in order to operate.
Oh, okay, cool. Thank you. I appreciate your time.
And then one more question that you had, Adriana, was the category you're given by the secretary.
Oh, the category that I was given by the secretary when I registered my business, is that the category you're talking about? When I asked the question earlier, I can't remember. Depending on where service, because I provide a service, and what I'm trying to do is I'm trying to integrate kind of like hospitality, home health, and personal assistant services under one branch, like a one-stop shop for home needs, because the name of my business is called The Good Life Essentials. You know what I mean? So I'm trying to, because I'm trained in home health, and then I do like housekeeping, I do like personal assistant stuff, like running errands. I transport people sometimes, and it's kind of hard to try and figure out what category to put that in or to like figure out what I'm gonna need.
Yeah, once you apply, are you talking about for the federal trademark, Adriana?
Yeah, for the
Okay.
trademark,
If
and
you're
then
doing
like,
an application, once you put your goods and services in there, the examiner will have to identify what industry you're in, what class you're in, and specifically. Honestly, it sounds like you're just in one class, but because it's one industry, but you may have like if you're doing apparel, that's a different class. If you're doing
mhm.
food, that's a different class. So
Well, I kind
typically one class falls under one industry. But once you do
okay,
that, you can look it up in our trademark manual. It's an ID manual, and in there it will have the different classes that you fall under.
okay, cool. Because I was even thinking about integrating like light maintenance or even like construction or something, but I know that that's a totally different like license and everything.
Yeah, I mean, at the end of the day, you have to show that you doing it in commerce in those industries. And I would say like the big companies, they typically in most businesses, they stick to what they're good at, right? Yeah, like even the big companies, they don't have all the trademarks. Yeah, like Apple and Samsung and Walmart. They have just the trademarks in specific industries that they're doing commerce in.
That they specialize in is what you're saying.
Hmm.
Okay.
Okay, it's 12 o'clock. But we have one more question, and then I'm going to move on to copyrights. And this is from Mr. Harvey. I developed an AI platform to perform my services. Can I copyright my AI platform? And then we can wait to George to answer that. And then it says, I named it after my business, but I'm curious about how to trademark this.
Okay. I mean, it really falls under George, so it's a good segue to George for the copyrights, which a lot of the
Okay.
software will fall under copyrights. But just to say, like, you could have a name for an algorithm. So, like the Google search algorithm, that's a trademark, and it's used in commerce. So, as long as it's used in commerce, it can identify the product. And in this particular case, the search engine, it can be trademarked. The source identification is key. It can be very broad, it can be very specific, but it has to specifically give consumers that source origin that we're looking for. That's why it can be colors, it can be scents, it can be broad, but at the end of the day, it's specific to a particular product or service.
Yeah, it's like everything around the home.
It's like distinguishing. Mhm.
Oh,
Okay.
sorry. I didn't know I was still unmuted.
Okay. Go ahead and mute yourself. Thank you, Judith. Okay. Reynaldo, Mr. Vasquez, thank you for your presentation on trademarks and all your answers. That was great. We had a great Q&A. And now we will bring on George from the Copyright Office. Okay.
Thank you, guys.
Okay.
And George is going to share his PowerPoint presentation, and then he will talk for 30 minutes, and then we will have another Q&A. And Ed, we will answer your questions during this copyright session.
Find yourself in copyright. That's what we're talking about today. Can you see the slide here? Can someone confirm that?
Yes, George, you look great.
Excellent. Great. So what does it have to do with you? Why are you finding yourself in copyright? I see there are 20 people online or so. We're going to see if we can make this a little bit interactive. So I have a question here. What is copyright? So just in a couple of words, put in the Q&A what you think copyright is, just from your understanding. I know you've all seen it. The C in the circle. You see it at the beginning of a movie. You see it in books, music. What do you think it is? Creative works of art? I see someone put in the chat. Protection of your ideas or product. These are great answers. Thank you for sharing your thoughts here. We're going to get into it. As you've seen already, there are different kinds of intellectual property rights. You just heard about trademark from Ronaldo. That's great. You now are experts. We're going to hear about patents later on. Today, we're going to talk about copyrights. Trade secrets are something different. Trade secrets have to do with, the recipe for Coca-Cola or the recipe for KFC chicken. And by the way to keep your trade secrets secret is don't tell anybody. That's very simplified, but that's basically it. Keep your secrets secret. But copyright protects original works of authorship. And when we talk about authorship, it's a lot more than writing. Authorship that's fixed in a tangible form of expression. And there are three things that have to happen. There has to be some expression of an idea. So you start with the idea, and then there comes something, the expression, the work. Has to be original to you. And it has to be fixed. And we're going to go over what these words mean, but they're important in this context here. It's been around since the beginning. It's in the Constitution. It talks about promoting the progress of science by securing for a limited time to authors the exclusive rights to their respective writings. And you'll hear a little bit more about this with the patent side, but it's the same clause that covers both. And in 1790, the first Copyright Act was passed, signed by George Washington. It covered books, maps, and charts. That's it. And it was 2 pages long. But some of those concepts in the original copyright law of 1790 still exist, even though the law has been amended many times since then. And again, it has to be original, has to be some work of authorship, and fixed in a tangible form of expression. There's that 1790 Copyright Act, 2 pages long. Today, printed out as 460 pages. Wow. But don't worry, you don't have to learn all those 460 pages here today. You're going to get the basics. And why is copyright so complicated now? Well, the way we do business is more complicated. There are more formats. It's more than just maps, charts, and books. And the way we do business is a lot more different than it was in the 1700s. We all know that. The law continues to be amended. One of the most recent changes was the Case Act, which set up a small claims court in the Copyright Office. It's called the Copyright Claims Board. This is really a really great resource because you can file an infringement case if somebody uses your work without permission, steals your work, in other words, and it only costs $100 to apply, whereas federal court can cost tens of thousands. And this is for claims less than $30,000, which applies to a lot of small businesses. And it's all online. You don't have to go anywhere. It's easy to file claims. You don't need to be an attorney. So this is a really wonderful resource that just came about within the past few years. It's been operational since June of 2022. So what are these works that are covered by copyright? Literary works. Literary works, by the way, include computer programs, which is a little unusual. Musical works, you all know about musical works, but that can be both the lyrics and the sheet music, as well as recordings. Dramatic works, pantomimes. I don't know if anybody does pantomimes anymore, but they're in there. Choreographic works, pictorial, graphic, and sculptural work, motion pictures, sound recordings, architectural work. So it covers a lot of different things, but not everything. It doesn't cover ideas. I mentioned this before. You have an idea, but it's the expression of the idea that is covered. Things like procedures and processes and systems and methods of operations, those kinds of things might be more on the patent side if you're looking for a procedure or some kind of a device that does something. And again, the concepts and the principles, they're not covered, not the idea, just the expression. It's got to be original, independent creation, and have some creativity, right? So now if you are standing next to somebody at a tourist site, come to Washington, D.C., take a picture of the Washington Monument. There are going to be 100 people next to you taking the same picture of the Washington Monument. Who owns the copyright? Well, you do, because you took that picture, even though it's pretty similar to the one your neighbor is taking next to you, but to you, it's original. And is it creative? Yeah, because you took that camera or your phone and you posed and you took the picture. That's the sufficient creativity it takes for copyright to be applied. And it's got to be fixed. What does this mean? It has to be recorded. Yeah, back in the 1700s, probably a quill pen, right? But today it's your phone or some other device. And why does that matter? I have a friend who does improv. None of that's covered by copyright because it's happening just at the moment, or somebody doing a poetry slam where they're just making up a poem on the spot, or singing, not written down, not recorded. Those are not covered by copyright because they're not saved or fixed in some way. Most things are fixed. But so here's a piece of trivia. I want you to chime in here. So you take a picture, you upload it to Instagram, your friend sees it, but then later it disappears. Is that covered by copyright? Is it fixed in the way I just described? What do you think on the Q&A? Yes or no? Is the photograph I took fixed? Yes, I see somebody saying. Any other brave souls? Yes, it is fixed. It disappeared later, but it was fixed for a period of time, long enough for somebody to see it, right? It was on Instagram, your friends saw it. Yeah, it disappeared, but and this is true, nothing disappears on the internet. But once it's out there, it's out there. So even if it disappears later on. There are a bundle of rights, okay? There are a bunch of rights. The right to make copies, copyright, okay? That's an obvious one. Derivative works. You write a screenplay, somebody makes a movie. That's a derivative work. The right to distribute the work to the public, to display your work, to perform it, and to authorize others to exercise these rights. And if somebody violates one of these rights, that's copyright infringement, unless an exception applies. There are exceptions. Why? Because the copyright law is a balance. It's a balance between the owners who own these rights and users, responsible users. So that's what copyright's all about. If you need to use someone else's work, ask permission. Or use something that's in the public domain where the copyright's expired, or consider some of the exceptions. Fair use, libraries have certain exceptions, face-to-face learning. Still not sure, ask a lawyer. Some of the limitations of exclusive rights. I mentioned those rights, but fair use is a carve-out that can be used as a defense, often in news or satire, things like that. You might be able to use portions of a work. If you work for a library, you may be able to use certain works. The first sale exemption means that you can sell something that you own, and certain performances, and also exceptions for blind and physically disabled persons. So I already said this, so take a guess again. What do you need to have for work to be protected under copyright? So chime in the Q&A, please. Which one is it? Be original, include a copyright notice, be of professional quality, or have a value of $35. Everybody knows this. Okay, that's good. You're paying attention. That's what I wanted. Be original. Yes, the quality doesn't matter. And we get a lot of works registered here that, well, anyway, we don't judge the quality. So when is it protected then? So you know what it needs. Is it when you mail a copy of the work to yourself, or when it's created and fixed in any format, or when it's submitted to the Copyright Office, or when it's published or displayed? Put those answers in the Q&A. Let's see if you are all as smart as I know that you are. Let's see some of these answers. It's B. The work is created and fixed in any format. That's what it needs to be protected. So what does that mean? That means as soon as you take that camera, right, and you take a picture or you write something down or record it, you got it. You got that copyright that instant, immediately. Now, there are extra protections that you get through copyright registration. And that's what the US Copyright Office does. So as I said, it exists automatically the moment you create that work and it's saved in some tangible medium. Then you can take an extra step to register that work. And it's not mandatory, but if you want to take somebody to court, either through federal court or the Copyright Claims Board, you need to register the work. Without registering it, you can't go any further and you can't enforce your rights. So that is creating a public record of your ownership is another reason, but this is really one of the main reasons. It's a ticket into court for filing infringement cases, and lets you pursue statutory damages. And so it creates that public record of creativity, but it's really an important step. So this is just because I like trivia. These are all real things. So what was the very first work registered under copyright law in 1790? Because I love history. And if you take a guess at this, I know this is very obscure, but I look forward to your guesses. Anybody venturing to guess? Lots of good guesses. And the answer is, it's a spelling book, the Philadelphia Spelling Book. Isn't that great? Anyway, I kind of like that. Philadelphia Spelling Book was the first work registered for copyright. And how about the first motion picture? Isn't just another fun thing. These are also all real things, all registered, all created around the same time. Any guesses on this one? You recognize at least, I know you recognize one of the names here. And the answer is, yes, it was Thomas Edison, and it was the blacksmith shop. And I'm not sure if that's playing here or not. Well, oh, there it is. Good. Okay. Yeah, a bunch of guys like hammering away on their blacksmith, on their anvil, and then at the end, they all take a swig of something. I'm not sure if that is safe work practices. I don't know what they're drinking there, but anyway, that's it. How long does it last? Okay, so copyright lasts the lifetime plus 70 years, and works made for hire 95 years from first publication or 120 years from creation. What are some of the business applications? Okay, for copyright, you have advertisements, have product brochures, you have pictures that represent your product. You might have a brochure, you might have a website, you might have a jingle for your commercial, you might have some other instruction manual. These are all written or visual or music that are associated with your business. And each one of these things can be registered for copyright. And the reason why it's a good idea, so you have your trademark, you might be eligible for a patent. We'll hear about that later. But you might also have a whole bunch of copyrighted materials, and you want to take advantage of all of that protection because you may need it, especially if something ends up on somebody's website and they're selling it. You want to go after them with your trademark. case and with your copyright case, and as much as you can now file infringement. You can go to our public records system and look up status of other people's works. And there are certain things that are in the public domain. And what does that mean, actually, the public domain? Anyone, based on this little trivia slide here?
Two of my
All right.
favorite characters, Betty Boop and Winnie the Pooh, entered public domain.
Yes, very good. D, it can be freely copied and used. And you're right. Mickey Mouse, the Steamboat Willie, Great Gatsby just came into the public domain, and Betty Boop, and Winnie the Pooh. When Winnie the Pooh, the first Winnie the Pooh book came into the public domain a few years ago, somebody made a slasher movie out of it. Hey, that's fine. Whatever you want to do, it's up to you. So those, after a while, the works come into the public domain and they're free to anybody to use. And documentation owned by the government is also in the public domain because it was never protected under copyright. The U.S. Copyright Office, we promote creativity and free expression by administering the nation's copyright laws. We're founded in 1870. We're a separate department within the Library of Congress. So we're not in the Department of Commerce like my colleagues here are. We're in the Library of Congress. And that's my building on the right there. I'm on the 4th floor. And we're right across from the U.S. Capitol and right next door to the Supreme Court. What we do, we maintain those public records, we create regulations, we advise Congress. We're 450 people, and we register about 500,000 applications for copyright every year that contain millions of works. Why are we in the Library of Congress? Well, because because of parts of copyright law, if you publish in the U.S., then you send your works to the Copyright Office, and they may become part of the Library of Congress collections. So that's the connection there. We register, like I said, about 415,000 claims a year. We answer 250,000 public inquiries a year. We record documents that have to do with the ownership of copyright, and we manage almost $2 billion in royalty fees for satellite and cable transmissions. So, another trivia for you. The model for which large object was registered at the Copyright Office? So which of these, the model for that was registered at the Copyright Office? Anybody guess on this one? A lot of good guesses here. I'm seeing A, B, and I'm waiting for somebody to guess C, the Statue of Liberty. That's right, it was registered, the model for the Statue of Liberty. Okay. Look at this cute monkey. This was a monkey that took a selfie. Yes or no? Can Noratu, that's the name of this monkey, who picked up a picture from a camera from wildlife photographer in Indonesia and took this selfie. Can a monkey own a copyright? Yes or no? Take a guess. What do you think? The answer is no, right? And the Supreme Court has affirmed this. Why? Because a monkey is not a human. So there has to be human authorship. So even though the monkey takes this adorable picture, and we have elephants who draw pictures with their trunks and all kinds of things that animals do, which is just lovely, they're not protected by copyright. So what about AI? Well, we have a lot of guidance on AI, and we're doing a lot of studies on this at the request of Congress. But the main question is there human authorship? So something created entirely by AI, the court has recently affirmed that that is not protected by copyright. Now, if you are using AI in the creation of some of your work, you can register the part that is created by you and exclude the part that is created by AI. Can get into some interesting gray areas, but we have a lot of guidance on this on our website, copyright.gov. That's the place to go. We are the authority on U.S. copyright law in the United States. In fact, we're the only place to go is the U.S. Copyright Office. So we have a lot of information there. Intellectual property is everywhere. We have a great little toolkit that explains all of this. And we have videos on YouTube that include cats. Everybody loves cats, right? And lots of information to help you learn about these concepts of what copyright is and how it applies to you. And like I say, in the business environment, there are a lot of products that you might not have thought about, especially with the brochures, the business materials, advertising, packaging. So all of that is potentially covered by copyright, and it's in your best interest to identify that and register it so you have that extra protection. You can subscribe to our newsletters here, connect with us online at copyright.gov, and we have YouTube, and that's where we are. I am.
Okay.
Yeah.
Thank you, George. Now we're open for Q&A. And while we're waiting for some questions to come in, I would like you to talk a little bit about work for hire.
Oh, yeah. So for some people, copyright is just what they create. But if in certain situations, there's a concept called the work made for hire. Okay. Now that applies for, let's say, Sony Pictures is making a movie. Okay. And they hire a whole bunch of people. And all those people are working on that movie. They are employees of Sony and they're working on the movie, and Sony registers the movie and Sony owns the rights. And all of those employees are working for the company, but they don't own the rights because they're regular employees of the company. There are also situations in which you can hire somebody and have a written contract with them. And in that situation, they're working for you, working on a project, and you have a written agreement which stipulates that you, the company, you meaning the company, own the rights rather than the person working on it. Now, what's really, really important for doing that is that you have to have that contract, that written agreement in place before you start the work. Do it in the beginning. There's so many situations where friends are working together, oh, I'll help you out on this, no problem. And then there's no written agreement. And then, a couple of years go by and the product is really successful. And the person comes back and says, hey, where's my money? I worked on this too. And then so that can get really, really dicey very quickly. So if you have that written agreement in place before you start, then it's very clear. You can get a lawyer to help you with that. A lot of these pro bono places that Ronaldo was mentioning can help with that to make sure to have that in place so that it's clear who owns the rights.
Okay, thank you. I have a question, and it said, and it's coming from our first presentation, but I said we would answer it now in copyrights. And Mr. Harvey says, I developed an AI platform to perform my services. Can I copyright my AI platform? I named it after my business, but I'm also curious about how to trademark this.
So as far as platforms are concerned, they're generally not covered by copyright, but it's possible that the software behind that, you might be able to register the software that runs a platform. But remember, what you're doing there is you're registering the software that runs the platform. You're not registering the output of the platform, right? You're only registering the software that runs it. So imagine Microsoft, they own copyright to Microsoft Word and PowerPoint and Excel, but they don't own the copyrights to everything that those programs create.
Okay. Now we have another question. This may be more about trademark than copyright, but I used AI to help design my business logo. Can I register it as my IP?
So I'm glad you brought that up because it's another interesting thing about logos. So logos, as Ronaldo was talking about, are often covered by trademark if they're used to identify a business or service. They might be registerable as copyrights as well, but it really depends. For example, the Nike swoosh, as was being shown earlier, there's not a lot of creative content there because generally colors and shapes and the numbers 5 and a check mark and a star and a square. Those are common shapes and symbols. They're not protected by copyright. Neither are facts like the 50 state capitals, for example. So a logo that has sufficient creative design could be also protected by copyright as well as trademark. But again, if you use AI, you have to, when you're registering that with us, you have to exclude the AI content and just include the work that you did yourself.
Thank you. Thank you. That's a good one. Okay. Is it possible to copyright a training course based on industry standards that are copyrighted?
So, yeah, this is kind of a two-part thing. If you write a training course, sure, that's a literary work essentially, and if there are pictures involved, there may be some visual art there. Now, if you're using someone else's work as a standard that you're basing it on, you need to make sure that you are not infringing on their work. So, it depends on what source you're using and whether it's a derivative work of that source or whether you're creating it on your own. So that's where you need to be careful to make sure that it's got to be original to you, right? So it's your original work. And remember, the copyright owner owns the rights to derivative works.
And then we have another question that says, can I copyright my AI logo I made?
Yeah, so again, I know we get a lot of questions about AI and it's on everybody's mind. And so the portion that your human created content is covered by copyright, but not the portion that is created by AI. And we do have a procedure for that when you're registering with us that you can exclude the content made by AI and let us know, and then you will still own the content that is yours.
Steffi, George,
Yes.
there's a question in the chat. It says, if you are a contracted business, like I guess a 1099 contractor, is your work copyrighted? And then a follow-up to that, what if there was no contract written?
So if a business can create content, copyrighted works, sure, and they are owned by the business. That happens as a matter of course normally. And as I mentioned, if you're using freelancers or people who are working for you and there's no written agreement, then that's where you might enter a gray area where you could get into a disagreement about whether the content is owned by the person who created the work, where there was no contract, no agreement. Then it might be that they own the work. So that's why I just again get that in writing ahead of time, and then you don't have to navigate who owns what because it can get sticky.
I get into this with my clients, with web developers and people they contract to make logos. And typically the people designing them own the copyright unless it's in the contract that you do.
Yeah, that's true. And because they've created it. And if there was nothing to say otherwise, then they've created the content. So if like I say, if you hire somebody, make sure that is made very clear in writing. Otherwise, they're gonna be the owners, and then you're gonna have to be using their work with their permission, and then they may want to charge you for that, and then you're gonna have a whole discussion that you don't want to have.
Okay. Thank you. That's good. That's the biggest one that we get all the time. Okay.
Yeah.
How long, we have another question. How long can a copyright logo or product last, and do you have to renew?
So copyright is different from both trademark and patent, that it lasts a long time. If it's just an individual creator, it's the life of the author plus 70 years. If it's a company, then it's 95 years from publication, or 120 years. So it's a long, long time, and you don't have to renew, and you don't have to prove that you're using it like you do with I know, at least with trademark. You just have it, and you don't have to use it at all if you don't want to.
There's no maintenance fees like the trademark maintenance
No,
fees and the patent trademark fees, maintenance fees.
right.
So if I looking to see if an existing picture or is in common domain, or that person that authored it has passed, is there a way to do a search on that?
Yeah, at this time, it is a little tricky because we don't have an image search kind of capability. You can search by the author's name, and when I say author, that means anybody who created content, even if it's visual or sound recordings or music, or by the title, or if it was published, for example, in a journal or a magazine or something. But we don't at this time have the capability to do an image search.
So one just has to see if that person passed or when the year was passed.
Right.
Okay.
Steffi, there's a question in the chat. It's from Jacqueline. And I'm going to allow Jacqueline to speak because it's a question that I think will need follow-up. It says, so can a certain type of artwork also fall under the trademark?
Yeah, so again, there are two different intellectual property rights, and the trademark, you heard about what that covers, and protecting your service or your business. And it might be protected under copyright as well if it has sufficient creative content. So if it's not just a red square, for example, that would not be creatively sufficient. But if there's sufficient artwork, um, then yes. So it's not necessarily that you can get both, but sometimes you can, depending if it's sufficiently creative.
Okay. And we're getting some of the Q&As in the chat, so I wasn't looking there. So sorry about that. And
Right.
we have a question about what about royalties if someone wants to use your work?
Yeah, so royalties can get tricky. If you're talking about musical works, there are performing rights organizations such as ASCAP and BMI, and they handle a lot of the rights to music. If you're talking about other kinds of products, you can contact the copyright owner directly and negotiate a contract with them. And really, it's up to you to make the deal that you want to make. So there are also royalties for different kinds of streaming of music, for example, and there are also royalties built into the law for satellite cable transmission.
Steffi, I allowed Jacqueline to speak.
Okay, go ahead.
Jacqueline, do you have a
Yes.
question you want to speak?
Can you hear me okay?
Yes.
Okay, great. I have a question. If one type of style of artwork is not necessarily, there's no contract, right, for copyright, but we can actually get it trademarked, would you have to get it trademarked before any kind of legal action is actually taken?
So there are two different processes, the trademark and the copyright. So I guess I'm not fully understanding your question.
So if it's not protected, like you just said, that if there was no contract and that product was already sold, the problem is that actual product, the original art piece of artwork, was scanned and sent to the buyer, wouldn't, and you kept the original, you didn't hand it off, would that still fall under their purchase? Like that would still be owned by them? They own the copy. We own the original.
Right. So copyright, let me explain that a little bit to you. I should have mentioned this earlier. So copyright covers the content, not the actual object. So imagine you have a painting, right, that you painted, and it ends up on a T-shirt somewhere. And that person who printed the T-shirt didn't ask for your permission to do that. Okay.
Mm-hmm.
That might be a copyright infringement because they copied the content of your painting. The painting itself might still be in your house or hanging on your wall. They didn't take the actual original object. They copied the content, and it's the content that is protected. So that's why an infringement, especially with visual arts, could be something appearing on a T-shirt or a coffee mug or anywhere else, because they're copying the content of the original work. So that's what is protected, not the object itself.
Okay. Let's say that product was purchased, no contract in place, and and you're trying to do, like, let's just say book. Is it possible to change one little element on that particular drawing and then it becomes new again?
Do you own the drawing?
My father does.
Okay. So your father owns the rights to that as soon as he created it.
Okay,
And
that's what I need to know.
yeah. Now, as I mentioned, registering it creates a public record, but he still owns it the moment he created it, and he has the right to create derivative works of that or to allow others to do that, either through a through written agreement. So, does that answer your question?
Yeah, it's really complicated when you have to come to patents, trademarks, and copyrights and how they fall under. Because I tried to register some of his cartoons, and I think it's like what, $15 to register one
45.
individual item each online.
Yeah, a little bit more, but we have some group registration options where you can register a whole group of things all together. So yeah, it does get complicated, and that's why we're here to try
Okay.
to help demystify it, because it can get a little tricky. But
Yeah, we've tried to go to attorneys, but it seems like nobody knows. Like there's Navajo Nation law, and then there's Arizona law, New Mexico law, and
mhm.
they all are not in line as well. So we hear different things.
Yeah, I hear you. And as I mentioned, there are a lot of pro bono sources for information. A lot of states have organizations for artists who provide free assistance.
Great. Thank you so much for your
hmm
time.
hmm
Okay, we got a couple more, and then we'll go into our next speaker. And what about quotes and commercial jingles? Can you
Sure. Well, jingles, probably yes. Could be protected by copyright. Another thing that is not protected by copyright is short phrases. Okay, so just do it. That's not protected by copyright. A short phrase. That's why you have so many books and movies called Love Story. It's a short phrase. A title or a short phrase is not protected by copyright. It might be protected by trademark if it's identifying a business or service, but it's not protected by copyright.
Okay, and then we have another one. Can I copyright AI music I made?
So yeah, that's the AI question. Again, that what you created, you can register, and it's protected by copyright, but not the AI portion.
And then can you get a trademark and a copyright on anything? Can you get both?
Yes, you can. Now, there are two separate processes, and you have to follow them both. independently. They're not dependent upon one another. So it's two different processes that you have to pursue to get those.
And then Adriana has a question about what about clip art or images from Google or Microsoft?
So this is a good question. Not everything you see on the internet is free to use. There are plenty of websites that have clip art and images, and they say, yeah, it's free to use. Here's a Creative Commons license, and you're free to use this. But you can't always assume that. We tell this to teenagers a lot, especially because they see everything and they're like, oh, I can use this. Great. But just because it's available easily doesn't mean that you can that you're free to use it.
I always tell anybody if they want to use it, anybody's an IP, they need to ask anybody's IP. So
That's
if
a
it's
good
not
approach.
theirs, if they didn't create it, it's somebody else's IP. Okay. What is the length criteria for it to be copyrighted?
So, like I mentioned, short phrases are not protected. There's no magic number, I'm afraid, but generally, it's not short words or phrases, but something longer than that.
Okay. We had a lot of questions during copyrights. George Tironi, thank you very much for coming and presenting to the New Mexico residents, small businesses. And so we're going to get ready for our next speaker.
Thank you.
Thank you very much. Our next speaker is going to be Hope Shimabuku, and she's going to be talking about patents. And you can start in a minute or go ahead and start, Hope.
Hope you might be muted on the phone. I believe it is star. Oh, let me tell you.
Do you want to dial up, Hope, and then come in on one of our...
I am dialed in. Can you hear me?
Okay.
Yeah, I'm on the phone. Yes.
Star 6.
So yeah, I went ahead and did that. And so thank you very much, Jeffy, and super excited to be here. Hard act to follow, as Ray and George were previously on right before me. Ray, if you wouldn't mind pulling up the slide deck, as Ray's going to be sharing slides for me. But today, I am going to be talking about patents. And just to give you a little bit of background about who I am while Ray is pulling up the slide deck, I am an intellectual property attorney by background, born and raised in Houston, Texas, went to school at UT Austin, if there are any Longhorns here. I got an undergraduate degree in mechanical engineering, made Sunny D and Hawaiian Punch before going to law school, where I worked for a couple of Fortune 500 companies, as well as worked at a couple of law firms before joining the USPTO about 10 years ago. And so, like my previous colleagues who shared about trademarks and on copyrights, I'm going to talk about the third bucket of intellectual property, which is patents. And so I'm going to go over a little bit about the USPTO with respect to that, but then I'm going to really just dive deep into patents and the different parts of patents. And so next slide, please, Ray. So as Ray mentioned, I am part of, or I head up the Southwest Regional Outreach Office. And a big part of our employee base is patents. And so we have patent examiners as well as judges that are part of the entire process with respect to our office. And so if you need any help or need to find information about our office or just would like to come and visit, the website is located above. Next slide, please. So just like when it comes to copyright, patent rights are actually founded in the U.S. Constitution. The patent portion of our agency is actually the oldest agency within the United States. And the reason is because of the patent rights that are explicitly granted as a result of the U.S. Constitution. And what does the Constitution say? It says, in order to promote the progress of science, that inventors for a limited time are granted exclusive rights to their discoveries. And discoveries are associated with patents. Now, as George mentioned earlier, what is also in this same phrase is the protection for authors for a limited time as well to their respective writings. But the U.S. Copyright Office is the authority or the registration agency for that particular aspect. Next slide, please. So when we're talking about patents, patents is what we call an exclusionary right. It's really not a right to do something. It is a right to exclude others from doing something without your permission if you are the patent owner. So what exactly does that mean, and what are the rights that are excluded? For patent owners, right, you have the right to be able to make, use, offer to sell, or import. So you can do that even without the patent. But if anyone else wants to do that, and you as the patent owner, you can exclude them from making, using, offering to sell, or importing anything that is described in your patent, specifically the invention. Now, property rights are granted country by country. And so we had mentioned before that the rights that the USPTO grants is associated only with protection within the United States and the territories. Any other rights that you want to get from an international organization, you'll have to go to that specific country's organization. So for example, if you want to get patent, copyright, or trademark protection in China, you'll need to go there to get that. Same thing in Japan, Korea, the European Union. The European Union has a way for you to get a coverage, especially with respect to patents, over several countries. But every other country, you do need to go ahead and go country by country in order to get those specific rights, including patent rights. And for patents, particularly utility patents, which is the typical patent that you think about, those rights are good for 20 years. Now let's go to the next slide, please. So why may you think about getting a patent? There's a couple of different reasons for them, and these are the examples that are listed on the screen here. One is what we talked about specifically on your excluding others from the market. So remember, patents are an exclusionary right. So sometimes you want to secure your monopoly or gain entry into that right, into the market, but then you also may want to consider excluding others from doing the exact same thing as you and to sell the exact same thing as yours and taking a competitive advantage. So that may be a place in which you want to get a patent. Other things you may want to do is to use it as a marketing tool to promote innovative, unique aspects of your particular product. Or if you want to set yourself up, it may be a way, because intellectual property is a property right. So every bucket of intellectual property that we're talking about, including patents, are a property right. You may want to set yourself or your business up to sell it or even to license it out. In intellectual property terms, licensing is like renting the particular product and letting others pay you a fee, a royalty fee, to be able to use that right. Next slide, please. So there are three different types of patents. The one that we commonly think about is what we call the utility patent. A utility patent is anything that is either a machine, article, manufacture, composition of matter, or anything that is new or improvement thereof. And I'll go into a little bit more detail and provide examples of what that might actually be. But this is your widget, the process for making that particular widget. It may be a manufacturing process. It may be the materials. Maybe you've come up with a new material for that particular widget. All of those things or any improvements upon that are typically covered by what we call a utility patent. Now, a design patent is anything that is associated with the look and feel, the ornamental features of a particular product. It's really the way something looks. So, for example, for your cellular phone, if you have a Samsung or an Apple, whichever one that you might have, the curves of the bezel or the curves of the actual screen itself, or actually the curve of the home button, or even whether it is an actual button or it is a slide, right? Those things are ornamental features. They're look and feels and not functional features of the phone, and that can be protected by design patent. A plant patent. A plant patent is anything that has some sort of human intervention associated with it, and that can be asexually reproduced. Now, a plant patent cannot be something that is naturally growing. So you can't go out and pick something like a blade of grass or pick a tree leaf off of a naturally growing tree or naturally growing grass that has had no human intervention associated with it. You can't get a patent for that. But if you've created something that's new, that you've done some sort of genetic alteration, and it can be asexually reproduced, then you may be able to get a plant patent. An example of that is the poinsettia, the red poinsettias that we see over the Christmas time frame. That is an example of a plant patent. So next slide, please. So this is what exactly are the things that you can get protected by a patent. We've talked a lot about what we can't get patented, the law of nature, E equals MC squared, gravity. Those things are things that cannot be protected by a patent. Same thing on literary works, dramatic, musical, and artistic works. That is something that you can get protected by copyright, but you're not going to be able to get that in and of itself to be protected by a patent. So what can be protected by a patent? We've talked about plants a little bit. We've also talked about designs. But there's a couple other things from a utility standpoint that you can think of. And specifically, that's a process, machine, article of manufacture, or composition of matter. And so let's take, for example, a tennis shoe. And let's say that you have created a new sole, and that new sole you've created is a brand new material. It has never, ever been seen before. You've created it, you've mixed together several different compounds, and you've created this new rubber sole that's associated with it. And it is particularly useful because it increases the friction and the grab against the ground, right? And so you've created this brand new sole. So if you've created this sole, that may be able to be protected as a composition of matter or as an article of manufacture because it's an actual product or widget or device in and of itself. Now let's hypothetically say that you've created a machine and you've built a machine to be able to cover or mold that particular sole. If that is new and useful and it's not been seen before, that may be something that you may be able to protect by a patent. Now let's hypothetically say that you've come up with a new manufacturing process of putting together a tennis shoe, including that sole. And so you have this assembly line that you've created. You take the fabric and then you glue on the actual sole, and then you put holes, you punch it in there so that you can thread the shoelaces through it. That entire process may also be something that can be patented. So these are different areas and different types of things that can be protected possibly by a patent. Go to the next slide, please. So for a utility patent, in order to get a utility patent, remember this is the most common type of patent, right? there are 3 things that have to happen, or 3 legal tests that have to happen in order for you to get a utility patent. Specifically, it has to be new, it has to be useful, and it has to be non-obvious. So useful is a pretty easy bar to be able to pass. You just have to be able to explain that it's something that it's useful, that you have actually created. But in order to get something to be patented, it also has to be new. It can't be something that has already been described or found in an existing patent application or in an existing granted patent or in a journal or anything else, so which evidences that it is not something that is new. So it has to be new, not only within the United States, but around the world as well. So it has to be something that is brand new. The other thing that it has to be is what we call non-obvious. And non-obvious is a little bit of a harder test to have, to explain. But the easiest way for me to explain this, and although this is not technically legally correct, but this is the easiest way for me to give you an example, is that if you have created a new blue bicycle and you got that patented, then you cannot then say, oh, now I've created a pink bicycle and try to get that patented. And the reason that you cannot is because this is an obvious variation of the blue bicycle. There are many, 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 many examples out there that we can see in which there's something that's been created as something blue and then something else that is also created that is pink. It is not a obvious enough or non-obvious variation of that bicycle. Now, on the other hand, if you take a bicycle seat and you've created a new material for that bicycle seat that allows you to be able to whisk away sweat as you're sitting on that seat, that may be something, if no one else has come up with it, that may be something that may be considered non-obvious. And the way that the examiner looks at this test is typically they'll take a patent application or a patent, and they will put them side by side next to each other. So they may have like 3 or 4 different patents that they have there. And they're looking at, for example, this bicycle seat, and then maybe they're looking at, I don't know, a chair seat or another material. And they're looking at this to see if this new material or this new variation, if it exists in 2 different things, if those 2 things can be combined together to determine whether it was an obvious variation, okay? And if the answer is no, it's not an obvious variation, then the possibility exists that you can get a patent for that, assuming you meet all of the other criteria. So let's go to the next slide, please. So how do you know something is new and non-obvious? And so one of the things that we usually recommend is that you do a search. And to do a search on patents that are existing in the system, you can use our databases to be able to help support that, to see if there's a patent application that's been published or a patent already that's existing that is similar or close to what you have already put together. If there is something that is already existing, then that is a good reason, or that may be a reason why you are not able to get that particular invention. So there are a couple of other places that our patent examiners actually look at to determine if something is new and non-obvious. Now, I mentioned the patents and the published patent applications. Those are things that are found within our databases at uspto.gov. But our patent examiners also look at foreign patents as well as published patent applications. They look at journals and articles, books, magazines, catalogs. They do a web search, and they look at different databases. They look at a lot of conferences and a lot of the papers that might be published associated with those conferences or separately. Those are a number of different places that they actually look to see if something is new and not obvious, and whether something has already been invented by someone else outside of our US and not strictly within our USPTO databases. If you ever want to find out more information or get some tips on searching, we have this series called Path to a Patent. And part 3, and we do this series, it's an 8-part series, we do it throughout the year, and we repeat it throughout the year. But the 3rd one in particular talks about searching, and it'll give you some tips and some different tricks that you can actually use in order to find something that's out there that may be similar to your invention. All right, next slide, please. So here's some additional reasons if just to find information or just to see if something had already been patented or invented out there is not enough. Here's a couple of other reasons for you to think about searching to be able to find some additional technical information, maybe some history and some marketing analysis, and to also determine whether there is anything that is prior art. And so what prior art is, it's anything that is before the date of your invention and it reads on your invention. And so it may describe either portions or the entire thing that you may be inventing. That body or that group of documentation, what we call that is prior art. Okay? Let's go to the next slide, please. Okay, so 2 different types of patent applications that you may have heard of. So a non-provisional application is the actual application that will eventually become a full-blown patent, right? This is what you have to file in order for something to become a patent. But in some cases, you may not be ready for a number of different reasons to file a non-provisional application. And what you might want to consider is a provisional application. A provisional application is really just a placeholder in time. It establishes a filing date. The person who gets to our office, USPTO first, to be able to and submits their application to our office is the person who is actually going to get that patent that's granted at the end of the day. So it's really what we call a race to the office. And so sometimes if you're not ready to file the full-blown application, the non-provisional application, then you might want to consider filing a provisional application. It's a shortened application. There is no claims that are required, and we'll talk a little bit about what that is in a little bit. It's not as expensive, but you only have it good for a year. And within that year, you have to convert it into a non-provisional application in order for a patent to be granted on that invention. So what may be some reasons that you might want to file a provisional application? Let's say, for example, you suddenly realized that you wanted to file a patent application for whatever you have discovered. And you call your patent attorney and you let them know, hey, I think we need to file this application. And then your patent attorney asks you the question, okay, great. When are you going to either launch the product or when are you going to publish your paper or your scientific research, or when are you going to be presenting on this particular invention that you've come up with? And you say, tomorrow. Well, no matter how good the patent attorney is, the likelihood of them being able to prepare a patent application within a couple of hours is probably unlikely. So what they might do in order to protect that before you show the public exactly what your invention is, then you might file a provisional application so you can take the time to be able to prepare the full-blown application and file the non-provisional. Now, in some cases, businesses may not be ready to be able to file and put in the expense for a non-provisional application. And so sometimes you may be in a situation in which either you're going to be doing a pitch competition coming up in which you're trying to secure funding. You may not know if this particular invention is the one that you want to go all in on because you don't know if it's going to be successful or you take off. And you want to have some sort of protection. And in some cases, even the pitch competition or whoever you're talking to about this particular invention may not sign a non-disclosure agreement or a confidentiality agreement. What you may want to do is to say, hey, I'm going to go ahead and file this so that they can't take it and then file it or steal it from me and then file the patent. So what you might want to do is to go ahead and file what we call a provisional application. It'll give you a modicum of protection. It will get you the patent pending status, which increases the likelihood of securing funding by 70% in some studies. And so you want to do this so you can do that with your provisional application. And then you have up to a year from when you file it to be able to convert it to a non-provisional application. The provisional application is never going to be published or examined unless you convert it to a non-provisional application. And so there are some circumstances in which sometimes, right, you can file a provisional application, you'll get a new date every single time, but it's on the same invention. And as long as you haven't disclosed it to anyone else or shared it publicly and talked about it publicly, then you can keep that provisional application, you can keep reapplying for it. But once you start disclosing it, once you start sharing it with other people, the clock starts, right? Whether it's actually in a provisional application or once you publicly disclose it, then the clock starts and you have a year from that initial disclosure to be able to file a non-provisional application, right? But that's a separate thing that we can talk about later with respect to disclosures if you want to talk more about that. But just note, a provisional application is something that you can file ahead of time in order to protect your invention, but you do need to convert it to a non-provisional application in order for you to secure your patent rights. Okay, let's go to the next slide, please. So I'm going to talk a little bit more in detail on what needs to be included in a patent application. I'm not going to talk a lot of detail into it. I'm going to give you a high level, and you are more than welcome to be able to get a copy of these slides. But I just want to tell you a little bit of what goes into a non-provisional application. Okay, so not the provisional, this is the non-provisional application. So the specification really is the written description of the invention. You're telling someone how someone can build it, right? You're giving them the background information that they need, and you need to give them enough information so that someone who is reading this can be able to make and use and build this particular thing. You have to be able to provide enough detail that it can be fully supported, or the claims, which we'll talk about a little bit later, claims will be fully supported. And you need to have enough information that someone called a pusita, or someone who is a person of ordinary skill in the technology, can make it and use it. So what does that exactly mean? So let's say you've come up with a new piece of software, right? Software, if you can describe it, you can take the executable code, you make it into a flow diagram, right? Once you do that flow diagram and then you describe it and someone is reading it, a software engineer, a computer programmer, or someone who is a subject matter expert in computer programming should be able to make it and build it and then use whatever you have described. You don't have to start from the basics of this is how you script, and these are the different codes, and then these are the different types of lines of script that you may have to have in your computer program. You don't have to go that basic. What you need to do is to be able to explain it in enough detail so that someone of that caliber who understands the technology can also make and use it. Okay, let's go to the next slide, please. So there are a couple of really standard pieces that are associated with your particular patent application. You have to give it a title, right? And it needs to have enough of a description, but so that someone who reads it can understand it, but it doesn't have to be super, super, super specific, all right? So you just need to have enough information in there so that someone can understand, hey, this is what this patent is about. Next slide, please. Something else that you'll need to include in there is an abstract. And in this case, an abstract for a patent is super short, right? It's 150 words or less, and it's only a single paragraph. And you're really talking about what's new in the actual technology or new in the invention that you are trying to describe. Next slide, please. And then you're going to be talking about the background. You need to give a little bit of information on the lay of the land, all right? Talk about, hey, this is really the history of where the technology is, what has already been developed, and then this is the field of invention that you are now coming into, and describe what is out there and what has come before you and why you are actually now inventing it. What is the problem that you are trying to solve as a result of your invention? Next slide, please. And then as well, you'll give a brief summary of your actual invention. So the abstract is super, super short, right? It's 150 words that we talked about earlier, but then you're going to give a little bit more details of what exactly your invention really is, and that's what's going to be included in the summary. Next slide, please. So drawings are optional, and it's not something that you actually have to include in a patent, but it is, honestly, I have never drafted a patent application or seen a patent that doesn't have a drawing. A drawing is extremely useful, is to be able to show what it is that you've created or you invented. The classic saying of a picture is 1,000 words is very apropos, I believe, when it comes to patents. And so, again, you don't have to necessarily include a drawing, but almost every application that I have ever seen has a drawing. And the drawing correlates to the specification so that someone is able to point to a specific drawing, and then the specification or the written description supports that, so they are back and forth. They're used together. So what a patent examiner will do in your specification, in your written description, you'll be describing what your invention is, and it will relate to the different parts of a particular drawing. Your drawings are numbered, right? They're labeled, and they have a number for each of the parts. And that number corresponds to a specific description that is in the written portion of the application, okay? One thing is that when you are including your drawing, it's important to be able to have different perspectives of the same item. So if your invention's on the inside of the actual invention, then it'll be important for you to show the drawing on the inside. And a front view, side views, internal views, the bottom view, all of those different perspectives to be able to show what the invention is will be important and should be a part of the drawings that you are submitting. Okay, next slide, please. So here's the detailed description and the written description that I was talking about. You want to be able to fully describe what you are inventing, right? And what the product is that you have included in your patent. Because what the examiner is going to be looking at, they're going to be looking at your invention, they're going to look at your figures, and they're going to be comparing the figures and making sure that you understand, or they understand exactly what is in there. Make sure that when you are describing your invention, that you're including the structures and the processes or the compositions of the inventions and the variations that are associated with that. If you have, for example, if you have an invention that can use different type of fasteners, right? A screw, a latch, a bolt, making sure that that is all included in there and the variations, so that someone who's reading this can understand that there are different substitutions for this particular piece, and this is just an example. So fully explaining exactly what it is, why it's important, and why you have these different pieces are going to be a big part of the detailed description that you're providing. Next slide, please. So before I launch into the claims are actually the most important part of your application. The claims in and of itself are the legal description of your patent. So a couple things to think about before you're actually putting together your claims, because drafting claims is an art form, really. And that's where you're paying the big bucks for your patent attorney to be able to draft this. And so as you're trying to figure out what you want to include in your claims, there's a couple of questions that may be helpful for you before you start putting together everything into your claims. The number one question that you need to ask yourself is, what is the invention? What is the true novel piece of what you have developed that distinguishes yourself from anything else that is out there or that has been created before or invented before? And what are the pieces or the individual pieces that make up that entire invention? If you have come up, for example, like the tennis shoe that I talked about, right? And if the inventive piece of that particular tennis shoe is the sole that you have created, you need to talk about the front part of the sole, back part of the sole, or even the different components or the materials associated with the sole. What is the critical piece about it? And then you can add different features that are in it. Maybe you have some skids on it or different other pieces or different parts, attachments that may be included, or even the tennis shoe pieces or parts that are associated with that. What is your core invention? What are the pieces and the parts? And then how do they relate to each other? The other thing that you need to do is you actually have to describe what the invention is, whether it's an apparatus, a machine, or composition. And then you can also think about whether there are other aspects to it. Is the actual making of the apparatus, machine, or composition the inventive piece, or the using of it, or is it the actual device itself? And so those are kind of a couple of different things that you need to ask yourself. And then, are there multiple versions of each invention? And so if you have different embodiments, like as I talked about, if you have that sole of the shoe that I keep coming back to, if you have several different types of materials that you can use for that new sole, right, different versions of it, then that may be something that you may want to consider as well as you're thinking about drafting your claims. Next slide, please. Okay, you have to have at least one claim included in any application, and it needs to describe the actual invention itself, right? There are terms and phrases that you are using in your claim, and whatever terms and phrases that you are using must also be supported in the actual description. So for example, if you are using the term fastener in your actual claim, then that term fastener needs to also be consistently used throughout the claim and also found in the written description and defined there. You can't use in a claim, for example, if you wanted to use the word bolt, and it clearly states in the bolt, and that's the word bolt has to be also included in the specification and defined there. If you only use the word bolt in claim and you never use it, use fasteners throughout your actual written description, then there's not going to be enough support in order to be able to describe what that is. So anything you put in the claim must also be included also in your written description. Okay, I know that I have about 9 minutes left, so let me speed through a couple of these things. Okay, here's a couple of do's and don'ts. As I mentioned, you need to make sure that everything matches in your claim as well as in your description. Think about what you need to be protecting and what is new. So let's go to the next slide. It's a list of don'ts. Again, I'm going to give you this if you are interested in reading this, so I won't go through a lot of this, but making sure that things are consistent. Don't use multiple sentences in one claim, right? And so these are just a couple of tips as well. Let's go to the next slide. And then when you're thinking strategically, right, thinking about what you want to accomplish, the goal of a claim is to make sure that you have exactly the right amount of things included in it. Think about a piece of land and the fence that you're drawing around it. You want to include just enough information so that you protect it as much as possible. You don't want to go too broad. You don't want to go outside of that fence, because then you're infringing or possibly reading onto someone else's patented item. But you also don't want it so narrow that only you can use it and no one else can use it, right? So you want to have as broad a scope as possible included in your claims, and so that you can have the biggest land as you can without stepping onto someone else's property at the end of the day. Okay, next slide, please. And then thinking economically, right? Every patent application, you pay the same amount for what we call 20 claims. And so making sure that you are using all 20 claims if possible, right, in one application, because if you have too much, then you'll have additional claims that you're going to have to pay for. But if you don't use all 20 claims, then it's almost like a waste of money, because you're paying for 20 claims regardless of whether you have 20 claims in there or not as well. And then look at the size of your company. There are certain discounts that we give. If you're a small entity, meaning that you have 500 or less employees, then you'll get a 60% discount. And then if you do not have a patent or more than 4 patents that you're listed as an inventor or have been assigned to you as a company, then you may be able to fall under what's called a microentity status, which gives you 80% discount. All right, next slide. So here's the patent examination process. So what happens is once you file an application, you send it into our office, then it's going to go through what we call pre-exam. The pre-exam is just formalities. It's looking if you have your drawings, all the pieces of your application together, you've paid the fee. It actually also gets coded because each technology area has a special code, and we want to make sure that they are funneled to the right examiner in that subject matter expertise. So all of that happens before it gets to the examiner. Once the examiner gets the application, they'll do a search, and then they will send you what's called an office action, and that is their evaluation of the search. And then there'll be this loop or the circle with you as the applicant on what needs to happen, because the examiner has questions. They explain why you can't get the patent because of the things that the examiner has found, and you are going back and forth with the examiner explaining to them why you should have it and why the things that they have found do not apply. At the end of the day, if you get a notice of allowance, then you'll get a granted patent. But then if not, there are a couple other decisions that you can make. You can either appeal the case, or you can actually decide, hey, this is not worth going after, and you may decide to actually abandon the application at the end of the day. Next slide, please. And this is what the issued patent actually looks like. All right, I'm going to go over, next slide, Ray. I'm going to go over a couple of resources real quick, and then I'll get to some of the questions, okay? So like the resources that Ray talked about on the trademark side, we also have them on the patent side. Here's one of the landing pages that are very common. It's a great place for you to start because we do have a lot of information on our website. So I'd recommend you start with our Startup Resources page, and then you can find all the information that you will need in order to help support your trademark or patent search. Next slide, please. We do have information online, free classes, and other things that you can find on our website. So please go onto our website, into our learning resources, and you can look at videos and other information as well to answer some of your questions. Next slide, please. We have a 1-800 number for inventors. So no matter what stage in the process of your patent, whether it's before, during the actual filing after you file the application or anything else, you can get your questions answered through the Inventors Assistance Center. Next slide, please. We do have partnerships around the entire country in which we have organizations that have volunteer attorneys that can help prepare your patent applications. The patenting process is an expensive process, and we do highly recommend that you use a patent professional because it is a fairly complicated process as well. And so you can go to our website to find the appropriate organization that covers your state. Next slide, please. We also have law school clinics, and these are law students that are supervised by practicing attorneys that can also help prepare your patent or your trademark applications. And so more information can also be found on our website on the local organizations or law schools that are providing the services within the state of New Mexico. Next slide, please. So patent and trademark resource centers are librarians who have been trained by our offices to answer simple IP questions as well as help you with a patent and trademark search. The closest one for you is in Las Cruces and at New Mexico Tech. And so they are a great resource for you. And I think that this is something that you should seriously consider reaching out to them for questions. Okay, next slide. All right, and that is it. And so if you have more questions, please feel free to reach out to me.
Thank you, Hope. That was great. I don't see any Q&A in there right now. And I know you didn't talk about design patents so much, but do you have to have permission from the original patent to use your design patent?
So if you have an improvement on something that was already created through a base patent, then you yourself do not need to get permission from the owner in order to patent the new improvement. So if you've created like there's a patent for a three-legged chair and you've created a fourth leg or a fifth leg, you don't have to get permission from the patent owner to file the application and get the patent for the fourth and fifth leg. But if you want to create and build the actual chair with the fourth leg, then yes, you need to go to the patent owner and license the rights to be able to create the chair with three legs, and then you can add your fourth leg to it. But you'll need to get that license from the owner of the three-legged chair patent first.
That one was always one that stumped me for sure. So, and we're on time. I'm going to go ahead and let Judy talk. And then after Judy talks, we're going to go into the survey. And then we're going to have Q&A for if you have any existing questions that you want answered. First, Judy will come on with the New Mexico Small Business Assistance Program. And then we'll do the survey, and then we'll have whatever time we have left for the Q&A. And I do want to thank Hope and George and Reynaldo so far for all your IP information. So thank you. Okay, thank you. Okay. Now we have,
see my stuff?
Yes, now we have Judy Hendricks from the New Mexico Small Business Administration Assistance Program.
Well, thanks so much.
Judy, before you go forward, and if you have any questions for patents, put them in the Q&A, please. Okay, thank you.
So I'm Judy Hendricks. I work at Sandia National Labs. We get a state tax credit to have the New Mexico Small Business Assistance Program. The idea, we got lots of expertise, engineers and scientists at our national labs here, Sandia and Los Alamos, and to use that expertise to help businesses. And this isn't complicated. I have, when it comes to patents, I think I have 10 or 11 patents, and it is complicated. Oops. But this isn't. This is a simple program, and it's free. So, NMSBA program, it's a joint program. Los Alamos and Sandia, we have shared this program. It was started by the state of New Mexico, knowing we have all those smart people at both our labs, and how can we use that expertise to help small businesses here in New Mexico? So That was definitely the goal. And like I say, the company, yeah, if you're a New Mexico company and for profit and small business, I'm really just excluding Intel. So, what do? We can do testing, evaluation, imaging, and modeling. The idea that you have a prototype. So for our program, if you just have an idea, you're too early for us. You could go to SCORE and maybe work on that idea, go to the SBDC and work on the idea. It's great if you have a prototype. So the idea, it doesn't cost you anything. We get a state tax credit that pays for the engineer's time. So the company does not receive any money or materials, but you get a written report. And hopefully that solves the challenge. Here you have a problem and you get a written report, hopefully with the solution. So if you have a technical challenge, someone's making new solar panels, they're creating the new solar panels. Sometimes they need help testing them. One company here, we're setting up the solar panel. We have a test facility for solar panels. We have places where we can do fire testing, drop zone testing, like that. Access to a special equipment. We have electron microscopes, spectrometers, hyperspectral imaging. Yeah, we have lots of expensive equipment. And the idea that you give us your prototype and our engineer actually runs the test. Sometimes you can be there to watch. Sometimes, like when we've done fire testing of materials, it's kind of cool. It's in a little box and it's all controlled. And you can actually watch the testing. And eventually you get a written report of the results. Do you need help testing the model or advanced imaging? So a lot of people don't realize, Sandia National Labs, we employ 17,000 people. Los Alamos employs about 11,000. So when you're talking about that many people, it's not just nuclear, it's everything. So wind energy, solar energy, and, pretty much any kind of engineering you can think of, civil, materials, environmental. We even have guys well-versed in geology. I used to do cancer research with lasers at Sandia. We have a whole biology building. We got chemistry, material science. We have robotics. We have a whole building of just the robotics. We have sensors, guys that are experts. We have drone. We actually have an indoor drone facility. Some companies that have created drones and want to test them inside in a controlled environment. That might be something we can do. What we do not do, we don't want to compete with commercially available stuff. So we're not going to make you a website. We're not going to make you an app, because you can go down the street and get a website, an app, right? Or even making a prototype. The idea, and it's changed over the years. I will say years ago, we might have made the prototype and then tested it. Now the idea is that the company makes a prototype and we can test it. Sometimes a company has like 3 prototypes and they're not sure which one's the best and how to test it. So that might be something we could do. So you don't receive money or materials. You get the written report of your test results. So, and we also partner, it's not just Los Alamos and Sandia. It's great. You go to our website and, you can say what you need help with in a couple of sentences. We work also with MEP, Manufacturing Extension Partnerships. They are the experts when it comes to lean manufacturing and even lean like process control. So if you need help with manufacturing, questions of manufacturing, how to get lean, how to make it more efficient, you apply to our website, and then sometimes MEP might be coming out to your business and looking at your, maybe new manufacturing line. We also work with the University of New Mexico, so the business school and the School of Engineering, and of course, New Mexico Tech and New Mexico State. So you don't have to decide. You just let us know what your challenge is. And maybe if it has to do with agricultural testing, we might go to New Mexico State. They do some shelf life testing. New Mexico have one thing, they want to test something that might explode. So, of course, we're going to New Mexico Tech. We'll see if we can do it within the budget. New Mexico Tech, they also do some product focus groups. So basically, you apply to the website and we figure out where does that challenge fit the best. And some of our success stories, remote well solutions, they have big solar panels and they use it to pump the water out of the wells. So they had the system, they just needed some help from our engineers. And now they're selling their systems to the reservations. Sandia Biotech, they do fluorescent antibodies and they needed some help with some expensive equipment testing. So they gave us their antibodies. We were able to test them and they get the report comparing their different antibodies for different fluorescents. So what do you have to do to get into this free program? You have to be a New Mexico company. Texas and Colorado companies have heard of this, of course, and they want in on it. You have to employ people here in New Mexico. So we get a state tax credit. So the idea is that the company's here, and even if you're doing R&D now, eventually you'll be successful and making, paying taxes here. So you have to be for profit. If you're a nonprofit, you don't pay taxes. A lot of nonprofits have a for-profit arm. So that's what we usually are working with. So it has to be a New Mexico company. You need your New Mexico tax ID number, the CIRS number. You need to employ people here. You have to be a small business. And that really, I'm just excluding Intel. So you can do it just on a sole proprietorship. And that's like using your social security number. And like we said, we're not going to do things that are reasonably available or that are available for a reasonable cost. So if you need basic water testing, most, years ago, 3D printing was something really unique. Now everyone has 3D printers, right? We don't do 3D printing, but once you 3D print your parts and create your prototype, maybe we can test it. So you're not getting cash or materials. You're getting the written report of the test results. And the work, is completed in the same calendar year. So for an individual project, it's just one company, the New Mexico for-profit business. And it's really simple to go to the website, tell us what you need. We could do testing, imaging, modeling. And the idea, the state legislators decided they wanted to help the companies in rural New Mexico. So if you're in Bernalillo County or Santa Fe, that's considered urban, you get $20,000 worth of assistance. If you're anywhere else, you're considered rural. If you're in Rio Rancho or Sandoval County is considered rural, you can get up to $40,000 worth of assistance. So once again, you don't receive the money, you get that much of the engineer's time working on your project. And the idea that it's really for the labor. So the engineer, we're not buying expensive stuff. Sometimes the one company needed expensive antibodies. Often they buy the antibodies, give them to us because then they have a lot more of the engineer's time to work on the project.
Judy,
And
we have a question, and just because you have a limited time, I'm going to go ahead and interrupt you. Is there a category for testing new construction material?
There, you can apply. Yeah. I'm doing something right now with some new Adobe bricks and things. We don't do what we would call like certification testing. So once you have to have something certified for construction, you pay for that, right? But you can do R&D testing, research and development testing. So yeah, definitely. And it does come down to a question of, do we have engineers that have time now to work on your project? So,
Thank you.
but
Thank you.
yeah, good question. So I just wanted to mention there's leverage projects. The individual projects, $20,000, $40,000 worth of the engineer's time. It's unburdened time. So it does go farther, especially now with the summer coming up. Sometimes you get summer students working on it. That's not a huge pot of money. So a leverage project, sometimes it's nice to do an individual project first. You get to know the engineer and things, and then you think of other cool things to do that maybe need a bigger budget. Companies can come in collectively together. We call it a leverage project. They, like I had a bunch of companies down in Alamogordo. One had drones, one had robots, one was making lithium batteries, and they had they wanted help figuring out actually the health of that lithium battery. So they came together, they write a proposal, do a presentation. Since there was like 3 or 4 companies from rural New Mexico, they could get up to $120,000 worth of assistance. But it was a shared challenge. So, and we do 2 calls per year for leverage, January and September. But that's when you send in your written proposal. For the individuals, you just apply, just, a sentence or two what you need help with. We've been in all counties throughout New Mexico. We've done a lot of stuff with the farmers and ranchers. We've done a cattle Fitbit. I've done solar work in cattle water troughs to prevent them from freezing. So yeah, construction, anything really. If it's a unique challenge, we probably can do it. It is free for the company. We ask that you do economic surveys, and we will hound you until you fill out your survey. So we want to know, when the project's done, did you hire people? Did you get a grant? Did it increase sales? So we collect that data and we go back to the state, because about every other year the state says they're going to do away with our state tax credits. So we have to go to the roundhouse and have, Sandia, we work with about 100 companies a year. Los Alamos is probably about 75. So we have to bring up a whole bunch of companies and say, yeah, we're really helping people, but we will bug you until the survey's done. So to apply, it's really simple. It's nsbaprogram.org. And really, a sentence or two, a paragraph. I need help with testing. One person, she created a new sewing tool. She had the prototype. She needed help testing it. So pretty much any type. And you submit. It's a 1-page form. What's your address? No PO boxes. I need your physical address in New Mexico. And your New Mexico tax ID number. And a project manager will contact you in 5 days to get more information. And then we try to find an engineer, and then hopefully meet with the engineer and talk about what you need and write a statement of work and get stuff signed off. I did just want to touch on Trigger, people. It's our new program. It's also a state tax credit. Trigger, you can get $150,000 of the engineer's time, which is a lot more, but there's a but. You have to have a CRADA, which is a big cooperation agreement. So you write a check for $5,000 and we do a big agreement, or you license intellectual property from Sandia or Los Alamos first. So you're writing a check maybe for a couple $1,000s to do an R&D license. And our IP are on the websites. If you go like ipsandia.gov, they'll list all the intellectual property we have to license. We do R&D, so we want to work with the small companies to help commercialize that. And here, currently, I'm at Sandia and John Martinez. Meg is the one up in Los Alamos. But just by going to that one website, just apply, and then we figure out what's the best fit for this challenge. And it's best to apply earlier, because we often run out of money come the fall. Could be summer, fall when we start running out of money. So Yeah, I think that's mine.
Okay,
That's it.
thank you, Judy.
Sure.
And just a reminder, I need to launch my poll right now, so if you can stop sharing, thank you. As Judy was saying, we have to report to our stakeholders, and we do that with a survey. I would like all of you to please complete the survey as we are needed it for our stakeholders. This allows us to continue to provide no-cost counseling and no-cost webinars like this, trainings. Our services are no cost, but we would like all of you to please all my attendees to please complete the poll, and probably you guys should see it up on the screen right now. I do want to thank Judy Hendricks on her program on New Mexico SBA. I want to thank George Tironi for presenting on copyrights. That was very good. You guys can turn on your videos. Also, Hope had to leave early as she is doing a presentation in she's at UNM, so she's here in New Mexico, so she's presenting at one of the classes. Also, Reynaldo Vasquez is these guys always present for me, so they're so wonderful. I do appreciate them coming in, and thank everybody for attending our World IP Day. If you do have any questions, continue to put them in the Q&A, and we still have our people around to answer any of the questions. I did have a question for Judy. Judy, do you test software?
Yes, we test software, but it's usually a lot of people when you have your software and you're selling it, right? That's a product. We don't really do product testing. We do research and development. So while you're creating your software, you might have a problem. You have your own software guys. We're not going to write your software for you. You're doing the software. You might just need help maybe with blockchain or one specific part. So often if we do software, I will say the software engineers are probably some of the busiest ones we have, but I have a number of software projects started. So yes, we do.
Do you test AI generated software?
No.
You don't? Does it have to be?
Well, no, yeah, I would say no. If you once AI, I'm software generated by AI, then I'm like, oh, you're done then, because we really want to work with your engineers while you're developing it, not when it's done.
Yeah, okay.
So, and I know some people that do software and they're saying that's like the worst thing ever. That I think a lot of people use it when they don't have a good grasp of software, and that's probably hard.
We have a question. What about unique idea for a business? Can that be a patent? And maybe you can answer that, Ronaldo.
So, I mean, patents are typically inventions. So typically will be widgets, but you can get a patent for a business method or process. So that can be a patent itself. As a matter of fact, a lot of the algorithms, if you look into patents for algorithms or business methods, you'll see like flowcharts and diagrams specifically of different inputs, different variables and outputs. Just a different way of doing something. That process can be patented. It's when you say idea, it's pretty broad. You have like for patents, it has to be very specific. Like Hope was mentioning, it has to be something in detail that somebody with the subject matter expertise can replicate. Just think about the innovation ecosystem that we have, and the patent system in particular is to advance technology advancement. So if you create something, show us how it's done so others can replicate it and can improve upon, and you'll get temporary monopoly rights for the up to 20 years to commercialize your patent.
Then we got another question. If I wanted to open a clinic, would that change the legality and requirements? From what? From your existing business? Let me see if I can allow her to talk. Just a minute. Okay, you can talk, Adriana.
Okay, can you guys hear me?
Yes.
Yes.
Okay, so what I'm meaning is like, because my business kind of leads towards home health anyway, and I'm trying to further my degree and get my associates and stuff. I'm doing things medical, anything like mental, physical, um, behavioral health, things like that. If I decided that I wanted to open my own clinic, um, how would I go about that? Would I still need to do trademarks, patents, and all that stuff? Like depending on, well, I guess of course, like if I did the logo like Happy Home Healthcare or whatever, and that jingle and all that stuff. But is there like other legalities to it? Probably on a federal level, right?
I mean, one of the things that you want to leverage, Adriana, is the SBDC advisors that you have here, and you really want to look into industry to specifically requirements that are needed. I know I used to work for the SBA, and I used to work with home health agencies. I mean, that's the number one thing that you want to look into specifically is what requirements are needed by the state and at the federal level, but mainly at the state level for your industry. Like the IP that we talk about, like patents and trademarks, copyrights, those are things that you have. I always tell businesses it's good for you to understand what they are so you can identify them. And at the end of the day, small businesses are limited to resources and risk and rewards. It's something that you want to gauge. And you have to really have an IP strategy on like what should I invest into? What's the most valuable? If you have like copyrights in there that are very valuable, then you would kind of go pursue that copyright protection the most. Or if you have a really good trademark, I get that a lot. People like they love their name, their trademark, and it's not to me, it's like it's your baby, right? You put the value
Yeah.
behind it, and you want to protect it as best as possible. But you have to remember you're limited to your resources, the time, the risk, and rewards of what it is. So you kind of have to decide what you want to spend time in. It's good to understand it. I think a lot of times for small businesses, the infringement part is the number one big thing that you want to consider because you don't want to create issues for yourself later on. Doing trademark searching, doing just some copyright search, that helps you understand the infringement part. Because if you do hit and you do develop then you want to, you can establish those trademarks later on in the federal level, or not everything for copyrights gets registered. I think George can kind of talk about how artists and industry does that, but they definitely register copyrights when they see it's valuable, right? I meet artists all the time that they don't register all their work, but the ones that they find the most valuable, they'll go ahead and do that extra step of registration.
Thank you, Reynaldo. And you reminded me that I had to do my pitch. So SBDCs provide training and we provide one-on-one counseling. We will be having another webinar this coming Thursday, April 30th, and it is about how to start up a business in New Mexico with emphasis on market analysis. And so Christopher, who stepped out because he takes his lunch break at this time, he's going to do a presentation for us. It's going to be what you need to be a small business. So then you can apply for Judy Hendricks' NMSBA program. And he's also going to do a market, talk about the tools we have here at the New Mexico Small Businesses to see where you stand when you're starting up a business. What is the market analysis? Who's going to be your customers? That's a big thing, who your clientele is going to be. And Christopher does a great job. So sign up, go to our New Mexico, nmsbdc.org website. We have a lot of trainings. Everybody's allowed to sign up for the trainings. And also, I want to thank the people that have replied to my survey. Thank you for replying. I'm going to leave it open for a little bit longer. I don't have 100%. I'm going to be like Judy and say we go after those surveys so we can have some data to provide to our stakeholders here. Again, happy World IP Day. Thanks Copyright Office, USPTO, NMSBA. I hope everybody has learned something about IP today. And any comments?
Thanks
George?
so much, Steffi. Thanks so
George,
much
do you want to
for
make a
organizing.
comment?
Well, I thank everybody for being here, and I think the message is that there are a lot of pieces to the puzzle, and the SBDC is here to help you put it all together, right?
Right.
Yeah.
And especially my program, the Technology Commercialization Accelerator, we're here to help answer some of those questions on IP. You will be receiving an email from me, and it will have the link to the stored presentation on our YouTube. And it will also have the attachments from these presentations, which are always so valuable. The Copyright Office website is copyright.gov. They have great website videos. It's not very hard to apply for copyright. I have a lot of clients that do it. I step them through it. I don't do the work. I step them through it, what needs to be done. USPTO, we work very well with them. They have their databases, so we do prior art searching. Reynaldo, I had a question. Hope mentioned PTRC at New Mexico Tech. Is that new, or am I the PTRC? You guys have a new PTRC here at New Mexico Tech?
I was trying to unmute myself. I think she meant the one in with Irwin. What's his name? John. But I know he's not.
Nathan, down
Nathan. Yeah.
at New Mexico State.
Yeah. I think she mentioned the wrong one, but yeah. In the map that we showed you, it's the correct one in there. In the website, the correct one is there.
Okay. Yeah, and we have that's what I do. I help people give them resources so you guys can continue. So make sure you reach out to me if you have questions. We can always get a hold of Reynaldo. We can always get a hold of George and Judy to introduce you to their programs that they have available. So thank you again for everybody attending. Again, thanks for the surveys, and sign up for our class for Thursday. Christopher will do a great job that will help you with your market analysis. Where are we? Who are your who's your target? And is it a good
Great.
idea to go forward with it?
Thanks so much. I appreciate it, Steffi.
Okay. Thank you guys.
Bye-bye.
You're getting, thank you all. Great presentation. So you guys are good.
Oh, thanks.
And I am going to stop recording. Okay. Again,
All right.
thank
Well,
you.
thank you. This was great.
Thank you. Happy World IP Day.
Yes. Okay.
Thank you,
All right.
Steffi.
Bye-bye.